for today.
Yes?
Prayers to take up the matter at 2 today.
No, we don't upgrade. You wait. We'll
Or
take up.
as the last item today.
We'll take up.
Obvious.
Yeah, please, Lordship. I beg to mention item number 5, Lordship. Kindly agenda matter for that, Lordship.
Item number 5.
5, Lordship.
Okay. On the prayer of Miss
Here you go.
A. Google Land Council for a petition of the cases passed over for the PP.
Obvious.
One criminal petition matter. Sorry.
Okay. Monday.
May I please your Lordship? Which I beg to mention item number 14, Lordship. Kindly agenda matter, Lordship.
Item number 14.
14, 1-4.
1-4. Okay. Miss.
S. Sud.
Okay. On the prayer of Miss S. Somlan, constituting for the petition. Cases passed over for the day.
Obvious.
Please consent to PP. Yes. Not 14th. After that.
May I please your Lordship?
After that, A receipt. Give it to the court master. Court master will give the date.
May I please your Lordship? I beg to mention one criminal petition for listing on 14 August for
No,
admission.
No. Give it to the court master. Court master will give the date next week, not this week.
I beg to mention item number 6, my lord.
Item number 6.
6. Pass over for the day.
Okay. On the prayer of Mr.
A. Mondal.
A. Mandal. Pass over for a day.
May I please, Your Lordship? I beg to mention one listing of a criminal petition. Next week.
Give it to the court master. Not for hearing. For orders.
Yes.
May I plead to Lordship? I beg to mention for listing one criminal appeal, Lordship.
Admission.
Yes, Lordship.
Admission.
Admission column.
Admission. Did you go?
May I please your Lordship? I beg to mention item number 2. I have filed the additional affidavit on 8th Friday. I can most humbly pray for the acquisition of the said additional affidavit.
You have not filed.
I have filed on 8th, your Lordship. This is the slip.
Get it listed and the day after tomorrow. Will not take up such manner. Yes, Mr. You are Mr. Sur.
Yes, sure.
Okay. What is it about? For Quashing?
Yes, your Lordship.
Okay, Mr. S. Sur, Land Council of petition. Earlier there was an order.
Yes, your Lordship.
37, my lord, directed to bring on record the search sheet.
That's it. I have filed the additional.
As Land Council of petition has submitted that he has an additional affidavit has been filed on
8/8/2025.
Post of release the case on Wednesday with the state additional affidavit stated to have been filed on 8/8/2025.
13/8.
8.
13.
Much of them.
Your Lordship, I beg to mention listing of an item criminal petition 211 of 2025 for admission.
Okay, give it to the court master.
Please, Your Lordship. I beg to mention for listing of 2 petitions. One criminal appeal. The petitioner is in jail for the last 1 year. And one criminal petition, it is fixed for hearing, but it should have been fixed for admission.
Admission. Okay, give it to the court master.
Lordship. Obvious, Lordship. May I please go ahead? Lordship, I'd like to mention item number 20 today. Criminal appeal. 20, item number 20.
22.
20, only 20.
Huh?
20.
20.
Only 20.
Yes. What do you want?
My lord, senior H. Bora, I'm appearing on behalf of him. He's unable to appear today. I'm appearing for H. Bora.
Yes.
My lord. He's unable to appear today.
He is?
Unable to appear today, so he's.
Okay, you want Passover?
My lord, a short date may be fixed. A short date may be fixed, my lord. If 1 week is possible, it is very.
The criminal appeal admission, it will be okay, we'll pass over for the day on the prayer of Mr.
You, sir, kya? You, sir, kya?
Use of Land Council for the appellant. For the case is passed over for the day.
Pass over for the day.
May I please, Your Lordship? Lordship, I beg to mention item number 38, Lordship. Up-to-date case diary was called for, but probably it is not before your Lordship.
38.
38.
Yes, Lordship.
Yes. Is they received? What is the subject matter?
Lordship, for quashing of FIR.
Okay, Miss
S. Yasmin.
S. Yasmin,
Yes, Lordship.
learned counsel for the petition is present with MP Goswami, learned additional public prosecutor, who is to obtain an up-to-date case diary.
No,
Soma received.
no, my lord, it was returned
Okay.
for updation, my lord, it is not received.
Soma has submitted that. Though the case diary has been sent for updation, the same has not been received. He has sought listing of the case when?
Any date after 10 days, my lord? I don't know.
13 days. Okay. This is the
First September.
No,
first September. To enable him to produce an up-to-date case diary.
Daily list for motion, item 1.
This is a quashing petition, my lord. According to GOP notification, my lord, notification is page number 26, my lord, annexation number 6. This case covers, my lord, under the notification, my lord, judicial department.
That is a policy
Yes.
yes.
that is up to the public prosecutor to move an application
yes,
before
ma'am.
the concerned civil court. What this court has to do?
My lord, several times.
Have you
request, my lord,
brought
the
this fact?
PP, my lord, several times.
Have you
request,
brought this fact to the knowledge of the learned trial court?
My lord,
That
learned
this
trial
is
court,
the policy
yes, my lord.
and my case falls under this policy.
Yes.
So public prosecutor should be asked whether he is intending to move any application under this policy.
My lord, Telgo,
Have you brought,
try to several times, my lord, to the
have you brought,
PP, my lord.
have you filed any petition?
Yes, my lord.
Where is that?
I have not annexed, my lord.
Where is that? And you have been
Then, my lord,
adjourning the matter for so many days. What this court has to do unless
my lord,
some order is passed on the
my lord,
petition?
My lord, last question, my lord. Landed people took time for 2 weeks time for regarding the information regarding the circulation matter.
Here the order reads like this. On the prayer of the learned counsel for the
My lord,
petitioner, list the
There is
matter
my
of
lord,
the 3 weeks.
I have seen, my lord,
I have
my lord, last occasion, my lord, is clearly submission in my lord by the landed people, my lord.
No, where,
Took the 2 weeks
where
time,
is your
my lord,
statement,
regarding
sir?
the
Where is
information.
your statement that you brought it to the knowledge of the trial court that I filed a petition and public prosecutor was asked to obtain instruction whether he would like to move petition under the policy or not? Where is that? This is a policy. It is a
Yes.
discretion of the public prosecutor, right? He may be questioned by the trial court. We do not like to
Yes.
question the public prosecutor of the trial
I
court.
will file my petition.
This is not the way.
Yes.
That this is a policy. Ultimately, it is
Yes,
a
my lord,
discretion
according
of
to
state
policy,
government.
According to policy, I have filed the petition.
State government will instruct the public prosecutor out there, not here.
Yes, ma'am. I
You
will
better
file
move
my-
an
I will file-
application. If you get an order, then only you can examine it.
Yes, ma'am. I will file my petition, my lord, before the land trial court, my lord.
This is
Yes.
is this a pressure
Reading
tactics?
of it, yeah.
Is this a pressure tactics? Filing a petition under
No.
482 here. Heard Mr.
Yes, Rama.
S. Raman, learned counsel for the petition, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. First, Mr. Raman, learned counsel for the petition, has submitted that the petitioner would more appropriate application would brought the policy notified by the state government by notification dated, notification number is 26, dated 21/10/2022, before the court of Landed, before the Landed trial court. And therefore, the petition does not want to pursue this petition at this stage. So, in view of the submission made by, above submission made by the Mr. Raman, learned counsel for the petitioner, this criminal petition is closed.
Obliged.
Item 3. Right, Your Lordship. This is even an application under section 528, my lord, for quashing the proceeding of CR case number 551/24, my lord. 551 of 24, my lord, pending before the Judicial Magistrate First Class, Kamrubat, Guwahati, my lord, against a complaint petition, my lord. This is a case, my lord, in between parents and daughter, my lord. Petitioner are the parents, my lord, and the opposite party who filed the complaint, she is the daughter, my lord. And you also will find the complaint at page 24, page 14, my lord, annexure A, my lord. What are the allegations are brought, my lord? So absurd, and my lord. Your lordship, may kindly turn to page 16, my lord, paragraph 3, my lord.
This is a complaint petition.
Yes, my lord. Yes, my lord.
So it has been registered. Thereafter,
registered.
cognizance taken.
I have
Cognizance taken.
notice issued, my lord. We have been asked to appear, my lord.
Cognizance. Okay. Oh, you were given opportunity.
Yes, yes, my lord. We have to appear, dear my lord. If we,
So you appeared.
no, we have not appeared as yet, my lord. That's
Huh?
before that I have come for quashing, my lord, here, my lord, for stay of the proceeding, my lord. Your lordship, kindly turn to page 16, my lord.
Did you appear? No.
No, I have not appeared as yet, my lord. We have not appeared personally, my
Because
my
now-
counsel appeared and filed petition there, my lord.
What petition file?
For my time, giving time, my lord.
Then you rush to this court.
Yes, because
You
your
had the
lordship is
first
still-
opportunity to oppose. Now under BNSS,
My lord,
if a complaint petition is filed,
my lord,
this accused who are supposed to be arraigned as an accused
my lord.
should be given the opportunity of hearing. Is it not?
And before that, my complainant has to be examined, my
Is
lord.
it
Before
not?
that, my lord. Complainant is also not examined, my lord.
The process has been changed now.
My lord, I have seen. 220.
Yes. 223.
Yes, my lord.
Proviso. First proviso.
Yes, my lord.
Because so that people do not come to this court, people do not come to this court at the drop of a hat,
But it is
at the
true.
drop of a complaint. What is the proviso? Please read
That is true,
223.
because this is a abuse of the process of the court, my lord, in my humble
Right?
conviction.
That is why it should be stopped at the trial court. Please read an
Yes,
intention.
I'll read, my lord. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant. That has not been done as yet, my lord.
Please
Yes,
read
my lord.
further.
And the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate.
Yes,
Provided that-
that's a moment.
My lord,
A magistrate having jurisdiction while taking cognizance.
my lord.
Right? First proviso.
Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard.
That is the intention, so that people do not rush to the High Court
My lord,
at the drop of a complaint by a complainant. The trial court will hear you,
my lord. But
give
before
all the opportunity. Thereafter, it will proceed to take cognizance.
that is but before that, my lord,
Then
complainant
why
has to be examined, my lord.
this kind of petitions will be flooded? This court will be flooded with this kind of petitions. That is not what is the object of behind this then.
The first paragraph, it says,
Mr. Goswami, please obtain the object and purpose behind incorporating this provision.
and before that, he has to be
Because
examined, my lord.
482 is not to be at the
No,
top of
it
a
will be misused.
complaint.
That I understand, my lord.
Because you are also
Yes, my lord,
misusing.
my lord, my lord,
If you put the allegation against the complainant
my lord.
that she is misusing, that you are also at the
That
same time,
That is true.
that
Because-
without
my lord,
appearing.
before issuing notice to us, my
I am
lord.
not very, it should have been,
My lord, before issuing notice to us, my lord, the complainant should be examined, my lord.
no, sir. The object and purpose. Because this kind of petition I have been receiving.
My lord, my lord. Of course, my lord, definitely.
And this court is flooded with this kind of petitions. Get the object and purpose for incorporating this particular proviso in 223.
Sir.
Because to stop
My lord,
using earlier 482, now 528, this provision has been incorporated to,
Of course,
it
ma'am.
is
true, my
my
lord.
normal understanding.
True, my lord. Sir.
so that the proposed accused are heard
Heard.
before
Yes,
taking
ma'am.
cognizance. This is the unique provision in BNSS.
Yes.
So just because you have been armed with an order of a coordinate bench, I will not proceed without the legislative intention.
Fine.
I am clear. So you show me object and purpose, because you have the full opportunity to dismantle the complainant's
Before
allegation
the magistrate, my lord.
to the magistrate. And you cannot say that magistrate does not know law. Get it at
No.
2 o'clock.
No.
We'll close this, giving full opportunity to him to contest the case as per the proviso.
My lords.
Otherwise, I have been receiving this kind of petition under
yes, sir.
582.
Because my
They
lord-
receive
yes,
notice from the trial court.
Trial court.
They don't go to the trial court.
Lord.
Come to this court,
Hmm.
528.
Hmm.
And this power is to be exercised only in exceptional situation. Am I clear?
Well,
Get it to
Yes.
we'll find out.
apply. Item 4.
Wait, please, hold on. No, this is petition, my lord, under 528 for quashing of a criminal case, my lord. So lordship will kindly see page number 20, the FIR, my lord.
Okay, page number 20.
Page number 20, my lord.
Let me read.
Yes, may I read, my lord?
Yes, please.
সন্মান সহকাৰে আপোনাক জনাও যে আজি 15/11/2016 তাৰিখে দিনৰ 11 মান বজাত মই হোজাই SBI বেংকৰ ওপৰত থকা লামজাৰী পাৰ্ক হোটেলৰ পৰা তললৈ নামি অহা পথত উপৰোক্ত বিবাদীজনে লগত আৰু অচিনাকি 2-3জন লগৰীয়া লগত লৈ মোক হঠাৎ এখন ছুৰী দেখুৱাই টকা দে বুলি আক্ৰমণ কৰি মোৰ হাতত পৰা মানি পাৰ্চখন কাঢ়ি নিয়ে আৰু মোৰ ডিঙিৰ হাতত গুৰুতৰভাৱে প্ৰহাৰ কৰাত মই চিঞৰ বাখৰ কৰাত থানাৰ কোনোবা এজন আৰক্ষী উপস্থিত হৈ বিবাদীৰ হাতৰ পৰা ছুৰীখন কাঢ়ি নিয়াত মোৰ প্ৰাণ ৰক্ষা পৰে। এনে অৱস্থাত বিবাদীজনে বেংকৰ লোকৰ সমাগমৰ মাজৰ পৰা পলায়ন কৰে। So my lord, this FIR,
With this Jabir
Jabir
Ahmed,
is the petitioner number 1, my lord.
Bibadi
Petitioner number
Oigyato,
Bibadi, my lord, one Mostu, my lord, Mostu.
Mostu.
Mostu. So
Okay.
these FIR, my lord, was registered under 341, 384, 325. Now lordship will see page number 22.
ছুৰী
Subsequently
দেখুৱাই
after,
মোৰ হাতৰ পৰা মানি পাৰ্চখন কাঢ়ি নিয়ে। Okay.
yes. Subsequently after investigation by the police filed charge sheet at page number 22. This is the charge sheet against Mustafa Uddin, that is alias Mostu,
Okay.
under my lord section 294, 323
Hmm.
at page number 24.
Hmm.
294, 323, my lord. Thereafter, my lord, the court took cognizance, and lordship will kindly see page number 28. This Mustafa Uddin, my lord,
Hmm.
he voluntarily appeared and pleaded guilty, my lord. And he was subsequently convicted under 294, 323, and he was sentenced, my lord. At page number 28.
Fine.
29, my lord.
28,
Okay, fine.
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 Okay, fine in default
Yes.
sentence.
Sentence.
Okay.
He was convicted, my lord.
Hmm.
Now, my lord, will kindly come to page number 34.
Hmm.
On the same day,
34.
my lord. On the same day, my lord, this Toizul Haq, who happened to be the son of this Mustafa Uddin, my lord,
Hmm.
he lodged an FIR against the present petitioners, my lord. May I read this FIR?
Hmm.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি 15/11/16 তাৰিখে চেম ডে মাইলৰ তাৰিখে পুৱা অনুমান 10টা মান বজাত চেম টাইম মই ও মোৰ পিতা মুস্তাফা উদ্দিন হোজাই ষ্টেট বেংকত 1,70,000 টকা জমা দিবলৈ গৈছিলো আৰু বেংকত 1 নম্বৰ বিবাদীৰ লগত মোৰ লাইনৰ বিষয় লৈ সামান্য মনোমালিন্য হোৱাত 1 নম্বৰ 2 নম্বৰ বিবাদীদ্বয়ে মোক বেংকৰ বাহিৰত আনি কিল ঘোষা মাৰি মাৰপিট কৰে আৰু এইটো স্থানীয় লোকে মিলাপ্ৰীতি কৰাই দিয়ে। পিছে বেংকৰ ID প্ৰুফৰ প্ৰয়োজন হোৱাত আবেলি 4টা মান বজাত মই বেংকৰ লাইনত থিয় হৈ আছিলো আৰু মোৰ পিতৃ চাইকেল লৈ ID প্ৰুফ আনিবলৈ বেংকৰ পৰা ঘৰলৈ যোৱা অৱস্থাত বিবাদীগণে গাড়ী নাম্বাৰ টুৱেন্সলৈ গোপালনগৰ আজমলৰ ঘৰৰ ওচৰত ৰাস্তাত মোৰ পিতৃক পথ আগচি ধৰি কিল ঘোষা ৰড লাখুটি দি মাৰপিট কৰি গুৰুত্বভাৱে জখম কৰে 1 লাখ টকা কাঢ়ি লৈ পলাই যায়। Now this FIR was registered under 147, 341, 324, 392. Where subsequently police submitted charge sheet against the present petitioners, my lord.
Hmm.
Now, my lord, this case is awaiting trial, my lord, against the present petition. Now, our submission is that, my lord, this FIR, second FIR is nothing but a counterblast to escape prosecution from the first FIR, my lord, where the informant's father himself had pleaded guilty.
Hmm. Now, in the second affair,
Yes,
it has mentioned two incidents.
2 parts, yes, 2 parts.
Another is at 4 o'clock.
At 4 o'clock. Now,
One is at 10 o'clock.
yes, my lord, we'll see at 10 o'clock.
It may be the second incident, maybe
Then
in
my lord,
consequence to the first
Then,
incident.
my lord, will kindly see page number 33. 33, my lord. It says that information was received in the police station
4 p.m.
at 4 p.m. How come, my lord, he have presented a typed FIR of an incident pertaining to 4 p.m., my lord, in the police station at 4 p.m., my lord?
That is recorded by police,
Yes,
but
Lordship, kindly see
page
page
34,
page
Yes.
39, Lordship.
39,
The
page
report of the
34 speaks about a second incident.
Yes, report of the investigation, my lord. Page 39, second paragraph. Verse
Page 30,
9, Lordship. Second paragraph, my lord.
39 second. paragraph.
Lordship, place of occurrence was visited and sketch map was prepared. Statement of the complainant witnesses were
There
recorded.
is a medical report also.
Medical report also, that is what I,
Hmm.
and there were injuries also, my lord. So there is something,
but
It cannot be readily said.
yes,
yes, but the foundation of this FIR
Foundation is
of
correct, but
incident at 10
it does not come within the parameters. Second incident
Yes.
may be as a consequence of the first
It may
incident.
be, but
It follows.
see the timing.
So that is a police, which police
Yes,
records
they-
it.
they
That is
say-
page 33.
Yes.
No.
But
they-
so
they-
far as if we read the FIR,
Yes,
there is a second incident.
second
second,
incident.
And because first he says this, whatever,
He does not mention about his father.
Mr. Toyjul Hawk, he
Yes.
says that মোক বেংকৰ বাহিৰত আনি কিল ঘুষা মাৰি মাৰপিট
Yes.
কৰে,
Yes.
right? It is he who was the injured in the first incident.
Yes,
In the second incident, his father was the
Yes.
injured.
But-
So we cannot readily infer that.
but your lordship will see both the affairs. Why
but
would
that
his
is-
father?
I could,
voluntarily
Mr.
appear-
Das, I could
Yes.
understand, but it does not fall within
Yes.
that parameters
It appears that
strictly.
yes, it appears that they had ambushed
What
him.
can be inferred is different thing.
My lord.
Your story is quite believable,
Yes,
but within the parameters to be exercised under 482 or 528 now, that may not fall.
but one thing, my lord, why would his father come into the picture when his father was not mentioned in the FIR and voluntarily
First
plead guilty?
incident could have been cross case.
Yes.
Right?
Yes,
This FIR has two parts.
Yes.
Second FIR.
yes,
First incident could have been a cross case of
Yes.
of this FIR
yes,
at page 20.
yes.
But second incident is not a case of, it is a consequence.
Consequence.
And consequence, because of the pleading guilty,
Yes,
that first part has come to a closure
yes, but
with his conviction of pleading guilty. But second
It-
incident, how can you read? There is an existence of medical report,
yes, there.
right? As on
Yes.
date, page 39, as per the
Right.
medical report, injury was simple, caused
Simple.
by blunt object,
object.
right? And medical report is part of the search sheet.
Yes, but my lord, the medical report will show as to who had received the injury, whether his father
No.
was the victim or yes,
that is
will have to be examined. my lord.
that is a
Yes.
case, so we have to see what
Yeah,
is the
yeah.
parameters
Yes,
for quashing.
yes, but
You have appeared or not?
I have not. Yes, I have appeared, my lord.
I have appeared. So
Yes.
you have the copy of the medical report also?
No, 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 no copy has not yet been delivered, my lord. It is fixed at this stage of because it's a summons procedure, my lord. It will be copy and offense explanation, my lord. No charges.
Summons procedure.
Yes, 341 and 320.
323 is summons
Yes.
procedure,
Not-
Yes, summons procedure.
maybe. So,
The next date is fixed on 16th, my lord, as the last opportunity, my lord, 16th of.
you appear? Who is Khalilur Rahman?
Khalilur Rahman has not been appeared.
You are not
my lord.
concerned with
The
Kolilur.
case was split up.
You are concerned with whom?
Jabir
Jabir and
Ahmed, my
Sayed.
lord.
You have
Yes.
appeared.
Yes, I have appeared, my lord.
Of having a privacy look cannot say that it is outrightly it is a case of passing.
My lord.
There is an existence of medical report. It is a
Yes.
second.
Yes. Lordship will examine that medical report, my lord, whether it pertains to, my lord, Mustafa Uddin or his son, my lord. Records will reveal, my lord.
Are you saying so with
Yes, because we have
full
not,
conviction?
because we have not.
See,
Yes.
we are using this 582 power on set parameters.
Yes.
Right? Now, last 6 decades, parameters are set.
My lord.
Yes.
Are you saying with full conviction that it is not, the medical
But
report
I
is
cannot
not?
at this stage say so, my lord.
Guesswork, with guesswork, we cannot proceed.
I cannot say so, my lord, because I have not got the copies, my lord, of the documents, my lord, including the medical report.
You go through the records, then you say. If it is really, then we'll pass. We'll pass. Otherwise, okay.
Or lordship will call for the records, my lord, scan copies.
Why should we do the exercise?
Then, my lord, we will file additional affidavit, my lord, we'll.
Get the information, make a
produce the
statement, then we'll do. If
Right.
that person, that father,
My lord.
whoever, in the second affair, has sustained the injury, then it is a
Then,
case
well,
for
it's a case of cross case.
prosecution. Whatever it may be.
Right.
It is up to you. I'm not finding any privacy cases on this.
No.
We need a set parameters.
Regarding the second incident, my lord. Yes.
At 4 o'clock.
Yes.
4 o'clock incident.
Yes.
It is up
But
to
the timing of the information received.
that is it. Police recording something.
That is also part of.
No,
the-
medical report is the vital one only.
Yes.
That's all. Okay, on the prayer of Mr. S. Das, Learning Council for the petition, is the case on so and so.
After 16, my lord, any day, my lord.
24. Go through the case record, find out
My lord.
in case of which the medical report
My lord.
is related. If it is son, okay, you have a case. If it is a father, you don't have a
No.
case.
21, my lord. Highly up.
Item 7. I have filed this criminal petition for recall of warrant. Here, what happened-
Recall of warrant.
Warrant. Here, what
Let
happened-
us see the FIR first.
FIR is at page 14, madam. Upon recovery.
What is
of
your
the-
name? Nehru.
Nehru, madam.
Nehru.
Nehru, madam. Page 14.
Nehru is involved with brown sugar activities.
Lordship, madam. 12.7
Today,
grams of
5/7 to Twitter is based on so and so contaminant brown sugar by some unscrupulous Nalapara parking who were caught by me. Seized 12 so and so suspected brown sugar. Seized as per procedure, Nehru Chetri. Date is 21B 29 5/7/2009. Then you were arrested, forwarded to custody. Okay. Thereafter, what happened?
Thereafter,
Investigation completed.
completed, my lord.
Let us see the
Thereafter, my lord, I was arrested, my lord, subsequently released on bail, my lord, and
After what? 55 days custody.
lordship, my lord. And my lord, thereafter,
Okay.
charge sheet has been submitted, my lord.
Search sheet, where is the search sheet?
Charge sheet, my lord, page 22, my lord.
Psychotropic substance,
22.
you FSL report means perhaps positive.
Yes.
21B.
And
Then
my
ultimately
lord,
when it was search sheeted,
lordship, my lord, I was charge sheeted, my lord.
date,
Date of charge sheet is, my lord, 13/10/2019, my lord.
13/10/2019. Then it has been registered as
Thereafter,
PRC, NDPS
lordship,
case,
NDPS,
Lordship.
negotiation judge.
page 24.
Okay, let us see the proceedings there.
Page 27, my lord.
Issue summons, initially issued summons.
Summon, my
No.
lord. Thereafter,
2021.
Yes.
21. Then 20.
Then thereafter, what is the report regarding summons?
Lordship, my lord, I am coming to that, my lord. Page 28, my lord, 18/11/2021, my lord. Accused persons are absent. summon-
Return unserved.
Return unsure, my lord. And thereafter, my lord,
Local people do not know Sanjay Setri.
Lordship, my lord. Thereafter, my lord, on subsequent dates, my lord,
What about Nehru's? There are two accused or what?
Two accused, my lord. I am for Nehru, my lord.
Nehru.
Nehru, my lord.
Someone issued has not returned. No,
And
about
thereafter, my lord,
so could not, house number so and so cannot be found. Let us see the address in the search sheet.
page
Nehru.
38 is relevant, my lord, thereafter, because my lord,
Nehru. Nehru. Porong, Kanapati, Bidupari.
Ramkhetri, residents of Karong.
Let us see the address. Nehru.
page 38,
Kanapati.
page 38, kindly see, my lord.
24.
Page 38, my lord.
We'll go one by one.
Page 38, my lord.
Accused person is absent. Transferred. COVID. Eleven two. 8/10. 11/2. 2000. Okay. Page 35.
Page 38, my lord. Page 35, 36, all are, my lord, NBW was reissued, my lord. And page 38,
Attachment also.
page 38, there is a reflection of my lord report, my lord, about my address, my lord. And page 39, 40, all are, my lord,
In the report, Nehru Chetty. In 11/2021. When proclamation issue proclamation without
it's, my lord, after issue of NBW, my lord,
Page 29,
page from page 29.
12/1/22.
On the first date, my lord, NBW was issued, my lord, and second date, my lord, PNA was issued, my lord. Page 29.
Yes, Mr. Goswami.
And my lord,
Yes.
prior to that, my lord, may I, my lord, submit one more thing, my lord. Page 50, your lordship has already seen, my lord, that is, my lord, impugn order, my lord. Where, page 50, my lord. 29/7/2025, my lord. On that day, my lord, co-accused was arrested, my lord, and case was filed against the petitioner, my lord, by standing the NBW.
Which page?
Page 50, my lord. Last order, my lord. Accused Sanjay Shetty is produced, my lord. Co-accused was arrested, my lord.
1 minute, 1 minute.
Page 51 is the last order.
So trace reminder.
First, my lord, addresses were given as Birubari, my lord. They don't give the proper address, my lord. Thereafter, my lord.
Okay, Sanjay Khetri was produced.
Lordship, my lord. This
Yes.
happens to be my cousin brother of the petitioner, my
Another
lord.
accused. Where is this order? 3/7/2023.
Page 38, my lord. I have already. Page 30 here.
38, lord.
Your lordship has just seen the order, my lord.
When for the first time NBW was issued?
It was issued, my lord, page 27, my lord. 11 to 2021, my lord. Why, my lord, someone as well as NBW was not served on me, my lord, because my lord,
Issue summons. No, that was summons.
Someone.
on
Then
their-
when NBW was issued first time?
Page 28, my lord, 18/11/2021, my lord.
Last order, was it?
Page 28, my lord, 18/11/2021.
And it was sent to where?
Sent to my lord Manipur, my lord. Why, my lord?
Manipur.
Manipur, my lord. Because, my lord, at that time, my lord, I was residing in Manipur. I am from, my lord, West Bengal, my lord. But I was born in
That
West
does
Bengal.
not say so. Your page 14 FIR does not say so. That is
Lordship, my lord. Page
what
14,
you
my lord.
have disclosed.
Lordship, my lord. Page 14, it says
Senapati, Manipur.
Manipur. Subsequently,
That-
my lord, I have shifted to, my lord, my native place, my lord, and I have annexed the documents, my lord. I have transferred my all the voter ID and, my lord, Aadhaar card, my lord. Page 52 and 53, my lord. Subsequently, I, my lord, shifted, my lord. Page 52 and 53, my lord. My present address, my lord.
So you did not inform the OC.
No, sir.
Hmm?
Lordship, my lord. Since I was, my lord, after release of
After bill,
Lordship, my lord. And as soon as I came to know about, my lord, issuance of NBW against me, my lord, on while arresting the co-accused, my lord, I inquired, my lord. Then I came to know, my lord, NBW also issued against me. And therefore, my lord, I came before this honorable court. I'm ready to appear, my lord. Since
you appear, we can only keep it in abeyance. Ultimately, it is a discretion of the trial court.
only that protection I need, my lord.
Only to that extent.
Lordship, my lord. I'll face the trial. And I made
You
categorically.
appear only within 15 days from today, Mr. Goswami.
Lordship,
Tomorrow is the date fixed for my appearance, my lord. So, my lord, I will appear tomorrow.
tomorrow.
Okay, লিখিব ভাল সোনকালে উলিয়াই দিব অৰ্ডাৰটো হাৰ্ড মিষ্টাৰ কে বৰুৱা learned counsel for the petitioner Mr. MP Goswami, learned additional public prosecutor for the respondent states. Full stop. The standard criminal petition under section 528 BMSS preliminative is preferred for setting aside and quashing of an order dated 18/11/2021 and other subsequent orders passed by the Court of Learned Additional Sessions Judge within bracket FTC. Number 3, Kamrup within bracket M, Guwahati Special Court. During the course of proceedings of NDPS case number 65/2020. Post of para. In an FIR, in a first information report lodged by Sub-Inspector of Police of Bokhisto Police Station before the officer in charge, Bokhisto Police Station on 5/7/2019, the petitioner was named as an accused along with another named Sanjoy Setri. Post of the FIR was lodged, stating it related based on specific information regarding selling of contraband within bracket brown sugar at Nalapara area, the two accused persons were apprehended, and from their position, contraband within brackets, contraband suspected to be brown sugar, weighing 12.73 grams, were recovered and seized. Full stop. The FIR was registered as Bokhisto Police Station, case number 1115/2019 under section 21 small b /29 narcotic drugs and substances of 1985. The petitioner was arrested and thereafter forwarded to the Court of Planet's Chief Judicial Magistrate, Kamrup Metro, on 6/7/2019. On being so forwarded, the petitioner was remanded to custody. Subsequently, after 55 days period of custody, the petitioner was CPS 21.
Lordship, my lord.
Shall not leave the territorial jurisdiction of so-and-so without prior written permission from him. So it was your duty,
Lordship, my lord.
to inform that I am going out. Is it not?
Lordship,
Piccolo? By an order dated 28/8/2019 of this court, passed in a bail application, PA number 2455/2019, prepared by the petitioner. One of the conditions for granting bail is that the petitioner shall not leave the territorial jurisdiction of the special judge under the NDPS Act, Kamrup Metro Guwahati, without prior written permission from the said court. After completion of investigation, the IO of the case submitted a charge sheet on 13/10/2019, finding sufficient materials to proceed against the petitioner and his co-accused. On receipt of on submission of charge sheet, the case was registered as NDPS case number 65/2020 before the special court. On 18/11/2000, 10/12/10/2021, the special court, after taking cognizance against the charge-sheeted accused persons, issued summons for their appearance. When summons were found not served, the special court on 18/11/2021 issued. When summons were summons were not returned after service, huh? So and so. Issued, ordered for issuance of non-bailable warrants of arrest against both the charge-seated accused persons, including the petitioner. Posted on 12/1/2022, the accused persons were found absent and the NBWs issued were found returned without execution. Posted. The special court then decided to issue order for proclamation and attachment against the accused person. Stop. During the subsequent period up to 7/10/2022, the warrants were found not executed. Full stop. On 7/10/2022, the special court issued order for issuance of fresh NBWA stroke attachment against the charge-seated accused persons. Full stop. As NBWA stroke proclamation and attachment orders were not executed, the special court on the subsequent dates ordered for issuance of fresh NBWA stroke PNA and also called for personal appearance of the jurisdictional officer in charge. Posted. When the case was posted on 9/4/2025, the officer in charge, jurisdictional officer in charge, was directed to execute the NBWA, submitted a report that the NBWA issued against the petitioner had not been returned. Posted. On 29/7/2025, the other charge-seated accused person, Sanjay Shetty, was produced before the special court upon execution of the NBWA issued against him. Posted. Taking note of the fact of not the execution of the NBWAs issued against the petitioner and an earlier order dated 3/7/2023. The special court observed that the address of the petitioner available in the case record was not proper, and accordingly, the petitioner was not found at that address. Post up. With such observation, the special court has ordered for filing of the case against the petitioner, keeping the warrants issued against him alive. Full stop. Para. It is right to state that every warrant of arrest issued by the court remains in force until it is cancelled by the state court or by the court which issued it, or until it is executed. Full stop. Therefore, the warrants of arrest issued against the petitioner are still in force and alive for execution. Close to. Para. It has been provided in section 84 of the BNSS that if any court has reason to believe that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, then such court may order for publication of a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publication of such proclamation. Full stop. The court issuing a proclamation may, for reasons to be recorded in writing, at any time after the issue of the proclamation, order the attachment of any property belonging to the proclaimed person. Full stop. Para. The petitioner has averred that after in a year 2020, he has shifted to his native place at Uttar Bagdogra, Darjeeling, along with his parents. And since then, he has been permanently residing at the said place in West Bengal. Full stop. Petitioner has also averred that he had transferred his voting rights to his native place and all his documents like Aadhaar card. In all his documents like Aadhaar card, etc. His address is mentioned as Uttar Bagdogra, District, Darjeeling, West Bengal. Full stop. Para. Petitioner has further averred that he has recently come to learn that the NBWS or stroke PNA orders have been issued by the special court during the proceedings of NDPS case number 65/2020. So, the petitioner has undertaken that he is ready and willing to participate in the further proceedings of NDPS case number 65/2020. Full stop. But it is the apprehension of him being taken into custody in execution of the NBWs issued against him. The petitioner has resigned himself from appearing before the special court. Full stop. It is further undertaken that in the event tomorrow, you want tomorrow?
Tomorrow, if I get the copy, my lord, I'm otherwise ready.
We don't know. Within a period of 10 days. if the NBW's issuing is him are kept in abeyance, a petitioner for a period of 10 days. The petitioner would appear before and submit himself to the jurisdiction of special court and would apply for bail. Also, Mr. Goswami, Learned Edition Public Prosecutor, has submitted that the proceedings of NDPS case number 65 of 2020 is pending since 2020 only for the purpose of appearance of the two accused persons, and it has not proceeded further from the stage of appearance. Full stop. And early conclusion of the trial of NDPS case is called for. Full stop. That are having regard to the fact situation obtaining in the case and the undertaking given by the petitioner in the aforestated manner, this court is of the considered view that for the purpose of facilitating an expeditious conclusion of the proceedings of NDPS case number 65 so and so, the NBW is issued against the petition since (18/11/2021) can be kept in abeyance for a period of 10 days if for enabling the petitioner to appear before a special court and of course it is therefore ordered that the NBW is issued against the petitioner by order dated so and so, and other subsequent orders are to be kept in abeyance for a period of 10 days. First of the petition shall appear before the special court within a period of 10 days, and if upon appearance he prefers an application seeking his release on bail, the special court shall consider the same in accordance with merits, on its own merits and in accordance with law. Full stop. It is made clear that in the event of failure or on the part of the petition to appear before the special court in a period of 10 days from today, the NBW is issued against the petitioner shall automatically revive. We don't know about this discussion. It is for the trial court.
Item 8.
Ratnadeep Gupta. Yes, Ratnadeep Gupta. Yes, sir.
May I plead your lordship?
Yes, madam.
Your lordship, this quashing petition was filed by Ratnadeep Gupta.
Hmm?
It was a
Ratnadeep
case.
Gupta.
Yes, your
Okay.
lordship.
What proceeding? Complaint proceeding is
Your lordship, the FIR was filed against him.
Rumi Mahajan.
Yes, on 9th.
Ratnadeep Gupta. Let us see the affair.
Yes, your lordship.
14 is I and accused had a registered marriage. After marriage, marital dispute, lost cases at present pending before the so and so in this regard. Call me, threaten me, new slang. We will file past cases, each inundation. I fixed for I went to Silchar, FTC court, and I was on the ground floor, parking. District judge, the accused finding me alone, started threatening, so I am not disposed of. When I protested, the accused used slang language against me and pulled me. In my mother, she was addressed. in front of people to save my dignity and enemy my home in front, try to make it settle. Try to with what I accused by the false complaint against me as a kind of the devil officer. When the FIR was lodged,
Your lordship, the FIR was lodged by the OP number 2 on
When?
19/7/2019, your lordship.
19/7/2019.
19. Yes, your lordship. Your lordship, the incident happened on
9/7.
9/7, your
Okay.
lordship.
Hmm.
Your lordship, I would like
Then
to.
investigated.
It was nothing was investigated, your lordship.
Huh?
Nothing was investigated, your lordship.
Nothing was, first it was submitted.
Nothing was investigated, your lordship. This kindly, your lordship, turn to page number 5, point number 9, your lordship.
We'll come to point number 9. Let us see the documents.
Yes, your lordship. No one.
So, where is the charge sheet? This is the charge sheet. Page 22.
There are
Yeah.
two search sheet, my lord.
No, I don't know. That is why.
Yes.
Huh.
There-
Oh,
Yes, your lordship.
page 22 is the charge sheet of what?
22, for the
Right.
same FIR, your lordship.
Seeing FIR. This is PS case number
2410.
2410.
2019.
Okay. What was the case found in the charge sheet? 506-341-294-354.
Yes,
Okay.
your lordship.
Okay. Then
Sir, actually, this case arose on the date of 9/7/2019
okay, that is I have understood.
when the petitioner was.
That was on 19/7 FIR was lodged.
Yes, your lordship.
Okay. Come to page 28. What is this? Okay, there is a different version.
Yes, your lordship.
Well, let us see that version also.
Yes.
I state when it was lodged.
It was lodged on 9/7/20
9/7 itself.
itself, your lordship. The petitioner
Okay, who is the person? Ratnadeep.
So, yes,
Let
your
us see what he has alleged. I will this case while I was returning from the court of science or justice, another court hold my hand, threatened, abused me with dirty language, slapped me on my pocket, told me if I took a present in the hearing of the case out of my hand pocket, she would just cut my neck, sharp weapon. Hard pocket. Giving a petition. So he was first.
Yes, your lordship.
He was first.
He was the
Right.
first one to lodge.
He
the
was
FIR.
first and he was ahead of you by 10 days. District judge, he informed the matter to the district judge.
Yes, your lordship.
Right?
Yes, your
Charge sheet was submitted when?
charge sheet was submitted on
39/2019. And your case
27, I think, lordship.
earlier.
Earlier, yes.
Now PRC case registered.
PRC case was already
Registered.
registered. Yes, your
Right?
lordship.
Then 2607 and
2607.
140/2024. Huh? What is the case, that one? 966 6. 39. 31/7. 19/7. 9/7. So,
Your lordship,
two affairs,
yes, yeah.
different versions.
Same version, your lordship, but it was a counter. The second one, the one that is impugned is counter blast, your lordship.
Your is the counter blast.
No, your lordship. I am for the petition.
How can we say? From records, it looks like that. Your is the counter blast.
Your
He
lordship.
was early in time by 10 days.
Yes, your lordship.
Right.
He is for the husband. ma'am.
I am for the husband only, your lordship.
Oh, see, you are for the husband.
Yes, your lordship. This is-
Okay.
The wife's version is the counter blast, your lordship.
Okay.
That is why I filed for the petition, your lordship.
Okay. The petitioner is Ratnadeep.
Not-
Yes, your lordship.
Okay. You want what?
We want the proceedings to be quashed, your lordship. It was malafidely done. They are
What is
already.
what is the stage, isn't it? What is the stage? Last order.
It is in the stage of charge, your lordship.
You have appeared.
Yes, your lordship, we have taken bail because the petitioner is an advocate. Ratnadeep Gupta is an advocate, your lordship.
Hmm?
He is an advocate, your lordship.
Ratnadeep Gupta advocate.
Yes, your lordship.
That is why you are ahead of 10 days.
The occurrence happened on 9/7, your lordship, and on the premises of the district and session judge in the parking lot, your
And
lordship. Your lordship.
Miss
Nam.
Miss Shashwati Kaur, your lordship.
S. Kaur, Land Counsel for the petitioner, and Mr. MP Goswami. And the lady is an advocate also.
No, your lordship.
MP Goswami, learned additional public prosecutor for the respond number 1, State of Assam. Post. The petitioner. Separated, divorced, what?
The divorce proceeding.
Separated or
Separated, your lordship. Divorce
separated?
proceeding is going on,
Okay.
your lordship.
Heard, Miss, the petitioner. And the respond number 2, who are husband and wife. Since solemnization of their marriage on 14/8/2023, are fighting a number of litigations. Post of it is stated that proceedings for their resolution of marriage by the decree of divorce is pending as on date. Post of one of such proceedings, which is pending between the said two parties, are or is which one? Before district judge?
It was already disposed, your lordship, on that time. It was already CA 28
One of
was
proceeding
disposed, your
pending on 9/7/2019 was
disposed, your lordship.
what kind of proceeding?
Sir, it was a criminal appeal, sir. Rising out of domestic violence.
Was pertaining to pertaining to a domestic violence act, pertaining to reliefs under the domestic violence of 2005. First of the petitioner has alleged that on 9/7/2019, an incident occurred outside the premises, outside the court of learned additional session judge FTC. Oh, criminal appeal number 20/2018. Outside the court of additional session judge FTC Silsor. But sorry, not mechanically correct. In the parking area of the premises of the district and session judge Silsor. Full stop. In a said incident, the response number 2. Had intimidated the petitioner and abused him, abused and slapped him. Post up in the process, response number 2 also torn the petitioner's shirt pocket. Narrating the incident, the petitioner lodged a first information report before the officer in charge, Silsor Police Station, on 9/7/2019, and the said FIR was registered as Silsor Police Station, case number 2314/2019, under sections 341, 294, 323, 427, 506, IPC. After investigation, a charge sheet was submitted by charge sheet number 966/2019 on 30/9/2019, finding a prima facie case under sections 294, 341, 352, 506, IPC against the respondent number 2, post para. The petitioner has approached this court by the instant petition under section 528B and SS, seeking setting aside and quashing of a proceedings of PRC case number 1140/2024, presently pending before the Court of Learned Judicial Magistrate First Class, Kasa Silsor. The case, PRC number 1140/2024 arose out of Silsor Police Station case number 2410/2019. The petitioner has contended that the FIR in connection with Silsor Police Station case number 2410/2019 was lost by the was lost by the respondent number 2 only on 19/7/2019. The respondent number 2 in the said FIR had projected the incident which occurred on 9/7/2019 in a different manner. It is expressly evident from the FIR that the FIR was lodged by the respondent, said FIR was lodged by the petitioner as a counterblast to the FIR lodged by the petitioner on 9/7/2019. After investigation, Silsor Police, a charge sheet was also submitted in connection with Silsor Police Station case number 2410/2019, PRC number 1140/2014, on by charge sheet number 7/2019 on 31/7/2019. The matter would require consideration, issue notice returnable on so and so date.
5/9.
As Mr. Goswami has appeared, accepted a formal notice. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post ready, having regard to the projections made and upon perusal of the materials brought on record. I am of the considered view that the petitioner has made out a case for interim relief. It is accordingly ordered in the interim that further proceedings of so and so, further proceedings of PRC, case number 1140/2024, arising out of Silsor Police Station case number 2410/2019, and presently pending before the Court of Learned Judicial Magistrate First Class, Silsor shall remain suspended till the returnable.
For admission, item 9.
Please, Your Honor.
Yes.
Your Honor, I'm being led by the learned ASGI, Mr. N. Venkatraman, in this matter. He's currently on his legs before the Supreme Court. So if Your Honor may consider having the matter at 2 after lunch. He'll be joining through VC.
Okay.
There's some difficulty on my part, my lords. I appear for the respondent number 4, my lords.
Is it a case assigned to this court?
It keeps coming back to this court.
I don't know because I am not holding the roster.
Yes.
Yes, Your Honor. I
I
think
am
because
holding
Your Honor had
criminal
passed the order in this matter.
Is there any order? I
there was a
passed
subti-
interim order. Interim order is
Order rejecting the interim.
Yes,
Ah,
in a sense, Your Honor, this writ petition, I think, is already infructuous because the orders have been granted that were needed and a separate investigation has also begun. So,
where is the petitioner side?
They've also lost interest.
They have lost interest or what?
maybe not. I cannot comment on that.
Okay, we'll call the matter in the second half. Petitioner side is also not
I'll
there.
cover you.
And if I find out whether this bench is assigned with this petition specifically.
Right.
If it is specifically assigned, okay, we'll take up. Otherwise, by the roster, it should go.
Yes.
Well, find out. We'll accommodate.
At
But
two-
let the petition side
I'll let them.
appear.
Item number 10.
Non-APS, the petitioner shall be heard. J. Hussain D. Das. Issue reminder, Juvenile Justice Board. Essential for legible scan copy. Further proceeding of PRC case number, Juvenile Justice Board shall remain state. Something regarding juvenility.
My lord.
Okay, let us see first what is the initiation. What is the initiation?
My lord, the instance,
Don't go to the impugn order at first.
my lord, impugn order is page
No, I'm not going to the impugn order at first.
29, page number
We'll
29.
we'll find out about the initiation first.
Page number 29, my lord.
Page number?
29.
No, I am asking you to go to the initiation.
Oh, my lord. My lord, actually, what happened in this case, my lord?
Yes, please.
The respondent number 2,
Respondent number 2,
that is the complainant of this case, my lord.
complainant.
My lord,
Okay,
she had filed a case. She had filed a complaint petition before the learned.
complaint petition.
My lord. Under
When? 2015.
2015, my lord.
Okay, 156.3.
3, my lord.
Hmm.
With a prayer to send the said complaint to the officer in charge of Khetri police station, my lord,
Khetri Police Station.
for registration of the case under section 494/506 IPC, 34 IPC. 494,
Second marriage kind of thing.
my lord,
Alleging against whom?
against the,
Who was her or who is her husband?
my lord,
Yes. Okay, Indrajit Sarkar.
Sarkar, alleged to have been the husband,
Alleged or
my lord, alleged,
let us see the content of the affair.
complete petition.
Legally married wife, she says.
My lord, in-
Marriage was solemnized, Karmakya debuter, 31/7/2008.
Case number 8.
Opposed, other accused persons opposed to the marriage between a complainant and accused. So after the marriage, taken me to her sister's house, Thirenpara, where they consummated and lived as husband and wife. Thereafter, complaint was taken by the accused. Dowry. Okay, contracted marriage. 2015. So she will be the first wife.
my lord,
As per the allegation.
Her
As per the allegation,
as per the allegation,
she will be the first wife.
first wife,
In 2015, you again contracted marriage.
my lord,
So that is the allegation.
that is the allegation.
Okay, then it has magistrate. What did he do?
My lord,
He forwarded the FIR.
my lord, not forwarded the FIR. My lord, the learned magistrate issued a notice and served
Notice,
a
where is it? Not
my lord, please have a look at page number 16, my lord. Sorry,
page number 16.
my lord, Page number 15, my lord.
15.
The officer in charge was directed to conduct a limited investigation under section 202 of the Code of Criminal Procedure and to submit a report on the same on or before 16/3/2016.
Okay.
My lord, on receipt of the copy of the complaint petition and the
Okay.
notice, the officer in charge of Khetri police station registered the case itself.
Okay, in 2016
My lord,
itself.
my lord.
Then
And after,
your statement was recorded
not my
in the
statement,
course of investigation.
the complainant's statement was recorded.
Yours was not recorded.
Not recorded.
Not recorded.
Not recorded.
Okay.
Thereafter,
Then
after completion of investigation,
uh,
the investigating officer submitted charge sheet.
this order was passed after what? After initial deposition of the complaint under section 200
My lord,
and any other witness?
no, my
Or
lord,
one more or
no, my lord.
huh?
No deposition was taken up.
Could not have. 202 comes after 200 or what?
Actually, my lord, it comes up.
202
it is
comes after 200.
Not, my lord.
If my mathematics is correct.
My lord, it is up to the satisfaction of the court, my lord, because the complaint was filed under section 156.
We are staying at page 22.
My lord, this is the 161 statement, my lord,
Okay, 161 statement.
after registration of case in the police station.
And what is this page 25?
My lord, page 55.
Page 25.
20. My lord, it is the deposition, evidence of the PW2 complainant, my lord, before the
Meaning thereby after investigation, trial is
That's it.
pending somewhere.
My lord, the after charge sheet was filed, the case, the cognizance was taken by the learned magistrate as DGM 2, and thereafter charge was framed.
When charge sheet was submitted. When charge sheet was submitted.
Charge sheet, my lord.
See, the complaint was in the year 2015, right?
My lord.
Or 16?
16, my lord.
16. 5/3/2016. Order to register the case was on, okay, in February basically, 2016, right?
My lord.
When the charge sheet was submitted.
I have not enclosed this charge sheet, my lord.
Tell me from your knowledge,
My lord, right now I have no.
because those might have bearing.
My lord, my lord. My lord, right now I have no copy, my lord.
Which year it was submitted?
My lord, charge sheet was submitted under section 494
Okay.
and 506.
Is there illegality?
This is, my lord, so far my case is concerned, it is illegal.
Okay, when it was submitted? Might be before 2019.
My lord, right now I am not in a position to.
No, we have to examine whether it is slumber or deep slumber.
Actually,
The lady was already examined
my lord,
as a witness, PW.
there are
2, meaning there was PW1 also,
my lord,
right?
PW1 also.
She was examined on 30 July 2019,
My lord.
right? Then what happened?
Thereafter, my lord, the petitioner took a plea that he is a juvenile, my lord.
Oh, juvenile.
My lord. Thereafter.
When?
Thereafter, my lord. After examining the PW2 complainant, her evidence in chief was recorded. And thereafter, the petitioner took a
On
plea
what basis?
on the basis of school certificate, school document.
What? Let us have the privilege of looking at that document also.
On the basis of the said school certificate, my lord, headmaster was called for by the learned magistrate and he was examined. Based on the said document, the petitioner was declared to be a juvenile.
Juvenile.
Well,
Okay, let us see the order. Let us see the order then.
Thereafter, the case was transferred.
Let us see the order.
Record is there, my lord.
No, have you annexed the order? Let us see.
My lord, the order that has been passed the Juvenile Justice Board, I have enclosed the said document as Annexure 5, my lord.
No, initially, please explain. Initially, the proceeding when the this complainant or your alleged wife was examined as PW2,
My lord.
the proceeding was pending before which court?
Now pending before.
No, please answer to my question. This page 25,
My lord.
she was examined as PW2,
My lord.
right?
My lord.
Before which court?
In the court of Chief Judicial Magistrate. My lord.
Chief Judicial Magistrate.
My lord.
It was in the year 2019,
19 months.
right?
My lord.
Then when you raised the plea of juvenility, I think you have raised the plea of juvenility before that court only.
Before the magistrate.
Then what happened?
Magistrate declared me juvenile.
Magistrate?
Magistrate, my lord.
Where is that order?
No, not page 29.
Huh?
But it is. Annexure 5 is not there. I have
Sir, you
my-
prepare a list of dates, then you come,
Mala.
we post it on another date.
my lord.
Right? It is not that the court is not the place where you can flip through and find out the dates. On the prayer of Mr.
J. Hussain, my lord.
J. Hussain, learning counsel for the petitioner, leaves the case on so and so.
My lord, one thing, my lord.
You prepare a list of dates, give it to me, short synopsis so that I can understand.
Stay order is there, my
Huh?
lord. Stay order is there, my lord. And the learned Juvenile Justice Board is asking the petitioner to remain present on each and every day, my lord. That is my problem, my lord.
So shall I make it limited?
My lord.
On 12/5/2024, the court observed that until further order,
My
shall
lord.
I make it limited?
Not my lord, the
Huh?
learned board is not understanding the order.
That way I cannot say. If the learned board is not.
No more.
Shall I make it limited that till the next set
No,
of
my lord.
listing?
Come last one.
You
27.
are a lawyer, you can make him understand the court.
My lord,
Until further order shall remain suspended.
every on
Is
each
it so
and
difficult?
case is fixing after 1.5 months later. Each and every day, the accused is.
Yes,
eager to-
it is not, he is not going to file the case. He has kept it pending.
My lord.
Has he proceeded further? Defying the order of this court?
My lord, it is the
Mr. Counsel, do you prepare a list? Don't interpret the order.
27/8. Item 11.
May I please, Lordship?
Yes.
Lordship, last occasion we have taken time to take instruction, Lordship. The petitioner has sent some document, Lordship, that I would like to present before this court with an additional affidavit, Lordship. 1 week time may be given.
What is this case?
Criminal
Criminal revision.
125
against 125 proceeding, my lord.
啊
10,000 has been directed to pay. He filed this petition, my lord. Thereafter, this honorable court, my lord, directed to pay the arrear
啊
by order dated 18/9/2024.
18/9/2024.
Thereafter, this or that player taken time.
Hmm.
Nothing has been paid till today.
What additional documents, sir?
Lordship,
The proceeding has been closed with 10,000 maintenance order.
yes, Lordship.
How can you?
All
Lordship,
trial court record is before
Interim
lordship.
or final?
Final, my lord.
Huh?
Final,
Final order.
lordship.
Lordship.
And
Lordship,
this is
what
revisional
additional
court, my lord. Revisional court further, my lord,
documents, my lord.
Oh, that is why I am asking why
Lordship-
additional
Lordship,
document.
thing is that, Lordship, the petitioner could not file written statement, Lordship.
Part of it.
Yes, Lordship.
Or petitioner could not file the written statement before the.
No, my lord, family court, Lordship. Yes,
Or
sorry,
could
he
not
then-
file along with this criminal revision petition. There are
Lordship. Sorry, Lordship. Sorry, Lordship, the.
Petitioner could not file written statement before the trial court.
No, Lordship, file, Lordship.
File.
Yes, Lordship.
Okay.
Lordship,
But you have not annexed it.
yeah, I have annexed, Lordship.
You have annexed.
Yes, Lordship.
Then
Lordship, he has taken personal loan, Lordship, before the passing of.
all these have been gone into.
14,000 that has to be paid, Lordship, every month, Lordship. And recent pay slip, Lordship, he will pay present before this court, Lordship. On that basis, Lordship, some reduction may be done in this order, Lordship.
Reduction.
Lordship,
Is okay on the prayer of Mr.
R. Islam.
R. Islam, learned counsel for the petitioner.
My lord,
The case is
I have objection, my lord.
again adjourned for 2 weeks. Post to Mr. H. Ahmed, learned counsel for the respondent, who has, who is present, has raised objection to the prayer for adjournment. Post of, as a petitioner, counsel for the petitioner submitted that he has some vital documents to having bearing in the outcome, and the same would be brought. Here's some so and so. Here's some vital documents having bearing on the outcome of the maintenance amount. Has sought for time. It is the case on so and so date.
5/9.
Before that, area may be directed to pay, my lord. Already it was directed, he is not compliant.
If I apply my mind, I'll apply my mind full, no half.
Lordship. Problem.
Hmm.
Item 12.
May I please, Your Lordship?
Yes.
Lordship, this criminal petition is for quashing of the FIR that at 8/10/2023. My lord, will please to find the FIR at page 13, my lord. Sorry. The allegation in the FIR is basically,
Let us read the FIR.
my lord, 13.
Let us read the FIR.
Yes, yes, madam. With reference to the subject cited above, I have the honor to inform you that as detailed, I along with HCB Binod Kumar Dubey, so and so, so and so, so and so, checking the train number so and so, while the train standing at platform number so and so today on 8/10/2023. During checking at about 8:30 AM, we noticed a person in a suspicious manner who was traveling in coach number so and so of the said train. On asking, he disclosed his name and address as Amarnath Osok Sawan, so and so years, son of so and so, so and so, and revealed that he is carrying 13 pieces of gold metal biscuit by tying around his waist without any documents. He also reveals that he carries gold regularly from Tripura to Maharashtra for smuggling purpose with the help of other members of the racket. Thereafter, he was deboarded from the train at platform number so and seized the said suspected to be gold metal under videography along with cash of rupees 64,500 and other articles. On being asked him to produce any documents about the recovered suspected gold, he failed to produce any documents nor satisfactory reply about the recovered gold. After that, the apprehended person and the recovered seized items are brought for further necessary action. That sir, the accused person is involved in smuggling of gold. This is suspected to be gold of total weight so and so, suspected to be smuggled and illegally transported without paying any taxes, etc., and without any valid documents, only to serve their ill motive and gain lawfully and illegally. That is the FIR basically. My lord, thereafter, my lord, will have a look at on that itself. It was registered under section 120B, section 379, section 411 and 413 IPC, my lord. So no offense can be constituted under these sections, my lord. So prima facie, from the FIR, no offense can be constituted from, any offense can be constituted.
Then ultimately, charge sheet was submitted.
Yes, my lord. Ultimately, charge sheet was submitted. My lord will please to find from page 18, the charge sheet, my lord, on 28/02/2024.
Okay. What did he say? IO?
The IO say the relevant portion will find at page 28, my lord. Translated type copy, my lord. May I read, my lord? The complaint is summarized as follows. Who is so and so at Posodia, Hiren, Sipun, slot number so and so, mail so and so, submitted a written complaint to the esteemed officer in charge of the station. However, the respected officer in charge did not take the complaint into consideration. Later on, investigation was initiated under case number so and so, and the investigation was assigned to ASI so and so, who conducted the investigation. The complainant stated that as a result of the investigation, gold belonging to Sonamini Basuni Gedasar was recovered and sent to San State Testing Center for examination.
Let us see the Assamese person.
My lord.
Let us see the Assamese person.
Yes. Brief of the case. অভিযোগ পত্ৰৰ সমূহ বিৱৰণী এই যে যোৱা ইংৰাজী 8-10-2023 তাৰিখে গোচৰীয়া হিৰেণপুন চুৱেঞ্চো আসামে অত্ৰ থানাৰ এখন লিখিত এজাহাৰ দিয়াত মাননীয় অত্ৰ থানাৰ প্ৰভাৰী মহোদয়ে উক্ত এজাহাৰখন পাই চলিত বছৰৰ গোচৰ নাম্বাৰ ইমান জুৰিত ভাৰপ্ৰাপ্ত ASI চুৱেঞ্চো দিয়াত ASI ডিপেনে তদন্ত কৰিছিল। তদন্তকালত পূৰ্বৰ তদন্তকাৰী বিষয়া তদন্ত কালত পদকীয়া গ্ৰেপ্তাৰ কৰিছে আৰু মকৰ্দমা সংক্ৰান্তে গ্ৰেপ্তাৰী পদকীয়াৰ পৰা উদ্ধাৰ হোৱা সোণখিনিৰ বামুণী মৈদামৰ সোণ টেষ্টিং চেণ্টাৰত পৰীক্ষা কৰাইছে আৰু ইতিমধ্যে উক্ত সোণৰ টেষ্টিং ৰিপৰ্ট সংগ্ৰহ কৰিছে। প্ৰকাশ থাকে যে পদকীয়াই আজি পৰ্যন্ত উক্ত জব্দকৃত সোণখিনিৰ কোনো বৈধ নথিপত্ৰ আদি আজি পৰ্যন্ত অত্ৰ থানাত চম যাব পৰা নাই। Whereas it is completely false, my lord, because we tried to submit our GST bill which have been annexed here, my lord, in the last page as annexure 5 page 31. They have denied to receive our GST bill, my lord. আৰু চৰকাৰক বৃহৎ পৰিমাণে কৰ ফাঁকি দিয়াৰ যথেষ্ট সাক্ষ্য প্ৰমাণ তথা পদকীয়াৰ স্বীকাৰোক্তিত পোৱা যোৱাত মকৰ্দমা অযথা পেলাই নাৰাখি ইতিমধ্যে মাননীয় প্ৰভাৰী মহোদয়ৰ পৰা অনুমোদন ৰায় মকৰ্দমা গ্ৰেপ্তাৰী পদকীয়া।
So your document is page 31.
Yes, my lord. So page 31. It was genuinely procured, my lord. It was genuinely bought, my lord. And more than that, how its section 379 will apply, my lord. So theft, somebody has to complain about that theft of the gold, my lord, and receiving of stolen property, both. A thief cannot be both. Either he is a thief or he should be a receiving of stolen property, my lord.
What is 413? IPC?
My lord, habitually receiving of stolen property. 411 is receiving of stolen property. Dishonestly receiving. Habitually dishonest. Habitually dealing in stolen property. Receive, habitually receives or deals in property. Reason to be stolen property. And my lord, already CD has been called for. CD is in the record itself.
So it did not appear in the trial.
Yes, my lord. So basically the allegation in the affair do not have a footing to stand on a trial. And already the trial has been stayed, my lord.
Recording in a region.
Give a reason to say. Any reason? My lord, it was simply stated.
Recording in a region.
No, I think.
Hmm?
No, I think. Well, orders.
Let's see.
My lord, it simply state, file order dated 6/5/2025. 6/5/2020.
No region.
Submission was considered that day.
No,
After
it
considering
is
the
not
submission,
reflected.
it's not reflected.
We can't say anything. You approach the Supreme Court also, or what?
No, my lord. Case has been completely covered by Bhajan Lal, my lord. The guidelines as laid down in the Bhajan Lal itself. The police has completed the investigation. While they have investigated the matter, they couldn't find any legal person who is the owner, alleged owner of the gold, my lord. Yes.
Yes, Mr.
Here, otherwise, prosecutor has seen the Caesar list, I think, my lord. Caesar list, the manner who is, he has,
Result is seized. That is a fact.
that is a fact, my lord,
That is a fact.
Yes.
13 pieces of gold biscuits or whatever
without any document.
were seized.
Yes, my lord. And second thing is that, my lord, if these sections are wrong, my lord, the charge is not yet framed, my lord.
But question is, what is the materials collected during the course of investigation?
My lord,
Because after FIR,
my lord,
FIR may not be an encyclopedia,
yes,
but after that investigation was complete,
my lord,
right?
my lord,
And during the course of investigation, the IO had all the liberty
my lord,
to make investigation and collect information to substantiate that these golds,
yes,
gold pieces,
my lord,
are either stolen or he was a receiver of stolen property.
my lord,
He was a habitual offender.
my lord,
He had committed cheating. He had conspired with others
my lord.
for 120B. Are there any materials? Simply seizure of gold.
Simply Caesar,
Pieces.
yes, my lord, Caesar,
So whether a person carrying gold, right,
my lord,
carrying gold, if gold is subject to tax, that is a different issue.
my lord,
Tax paid or not, that will lead to some offense under, say, gold order or something like that. But to attract the ingredients of the offenses, any of the offenses, may not be these offenses. What other offenses? There was no complaint that
okay,
these pieces of gold belong to Mr. X or Mr. Ms. State or say Excise Department or say some company. There is nothing.
there's nothing.
So how to proceed?
The only thing is that, my lord, here,
Possession of gold.
possession of gold and not showing any document and his statement,
Okay, let us admit
my lord,
not showing the gold.
my lord.
What would be the consequence?
My lord, because, my lord, here another thing is that perhaps he have stated, because I could not go through the other 161 statement, the records are very not readable,
You
actually,
should have-
not legible. But
Somehow you should have, because it is not that,
otherwise, his
not
statement
that
is,
it is unreadable.
it's
There
not
is nothing
It
in
is,
nothing.
it is
161.
readable.
readable, but it's
But sitting
difficult
in
to.
court, go through the case, there it is difficult unless
Yes, ma'am.
you go through it and point out something. as
But
well
his
get-
statement is there, my lord. He has earlier also.
But that is, there is a bar.
There is a problem.
The trial court cannot take
Yes.
that into consideration.
Yes, ma'am.
Whatever he says,
My lord. My lord. 161.
article
Yes, ma'am.
21
My lord.
or 22, right?
Yes.
And other what supporting materials you have collected? That this is a stolen, these golds are stolen.
So far, whatever.
From his Messrs. So and so jewelry, or say XYZ.
Yes, ma'am. That company is not there. To that effect, I have not found, my lord, that company.
So it may be
Smuggle also, maybe because the manner, it may be smuggled. Because,
maybe
my lord. Because he has also failed to produce any document.
that is a different thing.
He has also failed.
Suppose he fails.
My lord. And the quantity
So
is
the
not.
failure to produce document is an offense.
But otherwise, the quantity.
Quantity will be high, big.
Quantity. The quantity, yes, my lord. And the
Valuing
manner.
something.
Yes, my lord.
That could be evasion of tax.
My lord.
There could arise evasion of tax.
My lord.
Right. But there is no mention of any, say, red wheat.
Yes, not there.
Think it over. Tomorrow we'll take up,
My lord.
or day after tomorrow.
Depth.
My lord, day after tomorrow if possible. Day after tomorrow, my lord.
Think it over. Otherwise, no, appears to be no material. Okay, FIR, okay. But second time, investigation is complete.
Complete.
Now we can look into the materials collected during the course of investigation.
Yes.
Simply a person having possession of gold cannot be an offense under IPC. And if the, suppose it attracts tax, that evasion of tax could be an offense. But that is not under IPC perhaps.
Not under IPC.
And evasion of tax might attract penalty.
It can be
May
cured.
not be imprisonment.
Yes. Yes.
Look into it, the provisions of Gold Act or something like that. It may be an evasion of tax, if at best. Because nothing that it is of Burma origin or it is of this origin, that origin.
That is not there.
Huh?
That is not.
I think there is a certificate. Let us see.
That has been marked, my lord.
Yes, I did.
$24 carat. Pure.
Pure gold.
Nothing of their origin.
Only purities.
Purity is there only. It is gold. And the purity of the gold is 24%.
And the Indian standard
And the total
origin,
weight is 1513.618 gram. Yes.
and the Indian standard origin is 24 carats only.
Heard Mr. B.M. Deka, Land Council Board of Petitioner, on the request of Mr. R.R. Kosik, raised the case on Wednesday. Additional public prosecutor.
13.
You have interim order and the further order?
Yes, yes, my lord.
Oh, again, but it has been made limited. Interim order passed, I just shall continue till the next date of list.
My lord.
Item 13.
Yes, sir.
Please, your lordship, for the quashing the proceeding, lordship, the
Quashing of proceeding.
lordship, both parties are informant is the petition number 1, lordship. The land disputes are
1 minute.
all are the relatives, lordship.
First, let us see the FIR.
FIPS lordship 13, lordship.
13. Abed Ali Sarkar.
May I read, lordship?
Accused. In the FIR, okay, you are the informant.
Informant and petition number 1 is the informant and other the
Hey,
poet
take
is
it as some
lordship.
type of thing, case के लिए passing out 324 execute spinner and or give it said why it of a answer of the name.
Lordship,
Okay,
Lordship, may before kindly peruse the order dated 9/9/24. Perhaps what report was called for. Whether
Can copy.
my lord, in my note, this written as call for status report for trial court by
9/9?
9/9/2024.
Call for the scan copies.
Call for, and here it is written.
Scan copies of trial court record.
Yes, sir.
Yes, lordship.
That
Let us see the FIR first. This Rustom Ali.
Has
Is he part of the accused? P2. Salam Ali. Sanwar Hussain. Rejak Ali. Abdul Karim Sarkar. Sabdul Ali. Kadus. Shahjahan. Saiful. Surjat. Surjat. Saiful. Okay, in the FIR, about 15 persons were named. Out of that, 1, 2, 3, 4, 5. Now, 10 of them have joined in this petition, plus the informant. It was succeeded.
Lordship.
Or what are the offenses?
The offenses, Lordship.
325, 326, 447, 34. Let us see the FIR or charge sheet.
Lordship.
Page
18, Lordship.
Page?
Page 18.
18. Okay, now let us see Surjat.
Page 20, Lordship. The compromise affidavit, Lordship.
I'll come to that. We'll come to that. Okay, Surjat. P10. Let us come to page 16. Salam Ali's petition number? Sanwar.
3, Lordship. Another 4.
Sanwar is 4. Then Rejak?
5.
Petition number 5.
5, Lordship.
Abdul Karim?
6.
P6.
6.
Saidul Ali?
7.
Kudus?
8.
Shahjahan?
9.
Petition number 9.
9.
Saiful Ali?
11.
How many petitioners? 11.
11.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All 10 charge sheeted are joining the informant. Offenses are 141, 148, 149, 447, 325, 324, 323. This can be compounded or not? Which one is not compoundable?
Yes, Lordship. Going to Lordship, the
Which one is not compoundable?
compound.
What is the equivalent provision of section 320? In BNSS? 359.
359.
Now let us see 147 figures or not. Oh, these are the figures. Let us see 320. 323 compoundable. 324. Offense punishable under the sections in the first 2 columns. Compoundable. The person to hardest cause. 325 is compoundable.
$326 is not compoundable.
The charge sheet is not under 326.
Lordship.
447. (447) compoundable. 324. 324 is not compoundable, perhaps.
Yes.
Huh? 324 is not compoundable.
324 is not compoundable.
Hmm? Under section 320 CRPC.
Right.
Yes, where is the FIR?
Page 13 minutes. Sorry, yes.
And where is the source sheet?
18 minutes.
Yes, no purpose it is going to be served. Huh?
No, only 324 is there.
ঠিক আছে, order direction মনে pass করা। Order hard. Order. Hard Mr. N. Ahmed, Learned Counsel for the petitioners, and Mr. R. Kosik, Learned Additional Public Prosecutor for the respondent state. The instant in petition is preferred by the petitioners, 11 in number, seeking setting aside or invoking the power for inherent powers of this court under section 528, B and SS. Seeking setting aside and quashing of the criminal proceedings any PR case number, TRC?
GR case, Lordship.
PR?
GR case.
Where is that? GR case number?
4 Lordship.
Okay.
Page 1, Lordship.
GR case number 4477 stroke 2015, which arose out of Howley Police Station case number 432 stroke 2015, and which is presently pending before the court of?
Sub-Divisional Judicial Unit, Borveta.
Where have you mentioned?
Page number 1, Lordship. Title.
Before the court of learned Sub-Divisional Judicial Magistrate, Borpeta. Full stop. It is stated that on 14/7/2015, the petitioner as the petition number 1 as the informant lodged an FIR, first information report, before the officer in charge Howley Police Station, alleging inter alia that at around 8 a.m. on 17/7/2015, the accused persons, named in the FIR, forcefully entered into the plot of land which was in a position of the informant. Full stop. In the FIR, the informant had named 15 persons as accused. Full stop. The informant had alleged that after entering into the plot of land, the accused persons had assaulted the two brothers of the informant, and caused the injuries on their persons. Full stop. The accused persons had thereafter also assaulted the informant's mother and another brother. Full stop. On receipt of the said FIR, the officer in charge Howley Police Station registered the same as Howley Police Station case number 432 stroke 2015 under sections 447, 326, 325 stroke 34, IPC. An investigation ensued. Full stop. After completing the investigation in connection with so-and-so case number, the I of the case submitted a charge sheet under section 173(2) CRPC by charge sheet number 214 stroke 2015 on 31/8/2015. Full stop. In the charge sheet, out of the originally named 15 accused persons, only 10 of them were charge sheeted, stating that sufficient incriminatory materials were found against only 10 of them for committing the offenses under sections 147, 148, 149, 447, 325, 324, 323 IPC, case 16 or so. Most of the charge-sheeted accused persons are case 16 1 to 3 ke 10 ta ase tate packet di dibo A1 A2 ke A10 lole ha naam kita likhi. The aforementioned 10 charge-sheeted accused persons have joined the informant, Abed Ali Sarkar, to prepare the instant petition on the ground that subsequent to submission of the charge sheet on 31/8/2015, the parties have arrived. So the dispute between the parties subsequent to on the date of submission of the charge sheet. The parties have amicably settled the disputes between them by arriving at a settlement, full stop, in support of such compromise and settlement, the petition number 1 has sworn an affidavit before the notary on 31/8/2015, stating inter alia that though he had filed the FIR on 14/7/2015, he had subsequently compromised the matter as he found that the same was filed due to certain misconception about the accused persons. Full stop. The informant also stated that he was not interested to proceed the case as the informant. Full stop. Para. It is submitted by the learned counsel for the petitioner that as per the provisions of section 320, CIPC, few of the offenses are for which the petition number 1, 2 to petition number 11 were charged are compoundable as part of conditions prescribed therein. Post of, however, some other offenses are not compoundable. Post of paragraph 12 Gyan Singh. Paragraph 13 Narinder Singh. Paragraph 14 Lakshmi Narayan. Research. Yare Lakshmi Narayan paragraph. Paragraph 11.4, 11.5 for Parbot Bhai Ahir. Para. The provisions contained in section 528B and SS are perimeter to the provisions of section 482 CRPC. Poster. In the affidavit sworn by the petitioner number 1 as the informant on 31/8/2015, he had categorically stated that he was not interested to pursue further proceedings in connection with so-and-so police station case number, Howley police station case number 432/2015. Poster. Para. Meaning thereby, comma, even if the proceedings of GR case number is allowed to continue, comma, the possibility of a conviction is remote and the continuation of the criminal proceeding has the possibility of causing oppression and prejudice. Full stop. Para. It was 17 to likhe dibo. The police station case number, GR case number to likhe dibo. Officer 18 to likhe dibo. FIR to police station case number change kore dibo. 19. Close.
Item 15. Is your lordship.
Yes.
Appeal against acquittal in an NIA case, my lord. Leave was already granted, my lord.
Leave granted.
Leave has already been granted, my lord.
Acquittal.
Acquittal, my lord.
After this
Celestium judgment, my lord. But this was pre-Celestium, my lord. After Celestium judgment, now ordinarily appeal will have to go to the Sessions Court, my lord. But since here, my lord, leave was already granted before the judgment came.
So, is there anything, any observation in Celestial regarding
pending cases, no, my lord. Regarding pending cases.
Okay, I'll have the Celestial
My lord.
two
Two,
will
my lord.
pass the order. Otherwise, you have to admit.
Yes, my lord.
Because you will lose some, either of the parties will lose a forum.
My lord. Yes. Because if the person comes here, he loses.
But
the
if you are
second
successful
Yes, my lord.
here,
Yes.
then the other party has to go to the Supreme Court.
Supreme Court.
Right.
Even Celestium does not address one point, my lord, that if again in sessions, my lord, it was acquittal. Then if he comes to this honorable court, revisional court cannot turn a judgment of acquittal into conviction, my lord. That is another, my lord, gray area which is left there in Celestium, my lord.
But otherwise, in view of Celestial, the appropriate appellate forum would be Session Judge.
Sessions Court, my lord.
So appeal against acquittal.
Acquittal
right.
will go there.
Appeal is allowed.
Appeal is
So it will result into conviction.
my lord. But if appeal is dismissed, in that case, if he has to come, otherwise he has to come in a revision proceeding before this honorable court. But revisional court again cannot convert a finding of acquittal into conviction. But that is one gray area, my lord, which I have found, my lord. Perhaps the lordships will examine that.
No, it's still a piece of asylum. Okay, at 2.
At 2, my lord. Leave.
Some slight personal inconvenience today, my lord. Can this be taken up on any other date, my lord?
Okay. Next week?
Yes, my lord. On 16th or 17th, my lord, as your lordship pleases.
When?
On 17th, my lord.
17.
Yes, on 17th.
Or Sunday. 22nd?
Yes, my lord.
Okay. On the prayer of Mr. G. Chaudhary, Learned Counsel for the petitioner, leaves the case on 22nd. We have informed the other side.
No, my lord, the other side is the government, my lord. It's a public.
Kemprai, some name S. Kemprai.
Kemprai is for the complainant, my lord. He is a police officer, my lord. So I'll inform.
Okay. Police officer.
My lord.
Okay.
May it please your lordships. Am I audible and visible to your lordships?
Yes, yes.
We are grateful to this court, my lord. We are in item 9, which your lordships accommodated
Just a
immediately.
minute, let me complete the order. Okay. It is submitted that the prayer is made with the consent of the learned counsel for the respondents. You inform as Kemprai.
Yes.
Yes, please.
On
I'm
20.
so sorry, my lord. I didn't have thought your lordship would just say. I'm so sorry. My lord, item 9, your lordship was kind enough to accommodate me at 2 o'clock. Lord, it will not take much time. Can I be heard, my lord, so that can
Yes.
complete?
Yes.
Lordship, I am for the petitioner, Lordship. So they have submitted that the matter has become infract, right, Lordship. But we need some time to obtain instruction from the client, Lordship.
Okay. He is Mr.
N. Venkatraman. N. Venkat.
Okay. Yes, Mr. Venkatraman.
Yes.
A submission was made, I think, on behalf of your side, that subject matter has perhaps become infractious.
Well, for this reason, my lord, it is against, my lord, a 26-1 order they have come.
Yes.
And your lordships did not entertain an interim order. Division bench has also, my lord, rejected the interim order.
Yes.
And in the meanwhile, because there is no stay, we have also prepared the DG report. The investigation report is complete. And we have issued it to the parties, and they have to partake, my lord, and the adjudication process has to happen. So it's this formal process now of the petition being heard in your lordship. If they want to still, that is all is pending now. So I mean, my friend
Right.
should be, whenever he wants to do,
Yes.
but should do it without any further delay.
Okay. So, Mr. Counsel.
Got it, Your Lordship.
Yes, what will be your convenience that then they want to take instruction whether they would pursue the writ petition or not?
Okay, 30th August, if it's 30th August.
That is Saturday.
Oh, sorry. My lord, immediately that Monday, my lord, following Monday.
Okay.
1st September.
1st September.
1st
Yes.
September.
My lord.
Okay.
We'll try to complete it on that day for your lordship's leave.
We have filed with you. P.K. Bora, right?
Yes, Your Lordship.
Mr. P.K. Bora, learned counsel for the petitioner, Mr. S. Venkatraman. N. Venkatraman, learned additional Solicitor General of India.
Yes.
Assisted by Mr. D. Das. Learned counsel for the respondent number 2 and 3. And Mr. B. Chaudhary, learned counsel for the respondent number 1 are present. Anybody else?
On the number 4, minutes.
Respondent number 4. Who is for the respondent number 1?
I think all of us, the only agreed party is CCI, but everything else is.
Yes. Any central government council? No. Okay. Mr. Bora, learned counsel for the petitioner, and Mr. Chaudhary, learned counsel for the respondent number 4, have both sought a short accommodation. First of, it is submitted by Mr. So-and-so, ASGY, Additional Solicitor General of India, that due to subsequent development matter, perhaps subject matter of the petition may perhaps be infractious, be that as it may, the respondent there is certain urgency on the part of the respondent number 2 and 3. Full stop. Mr. Bora, in response, Mr. Bora has submitted that he will take further instruction in the matter. Full stop, as agreed to and as sought for by the learned counsel for the parties, placed the case on 1st of September 2025.
Extreme your place, your lordship, for the accommodation.
Yes.
Can I exit your lordship's court?
Yes. 1st of September.
Obliged.
Item 15.
Oh, yes. Okay, this, whatever. So
Celestium has given the option, my lord. Then
Yes.
as a complainant, he can pursue it.
In that, those cases, 4 weeks.
My lord.
But, solicitors. This option is also available.
Yes, my lord. If he chooses to prosecute it as a complainant, my lord, in that case, leave will be required under 378(4). Relevant paragraphs.
I think in the original order, paragraph 9 perhaps, in such a case, an appeal can be preferred either under the proviso
Yes, ma'am.
to section 372 or under section 378 by such a victim,
Yes, ma'am.
right?
Yes, ma'am.
Okay. This would be, pendency will be longer here
Yes, ma'am. But this is
than the sessions court, perhaps.
because this is a case which
No, pendency will be pendency till disposal will be longer here, perhaps than the
Sessions court.
pendency period before the sessions court. It is for you to choose.
My lord, because in this case, my lord, this is a case with simple arithmetical error on the part of the trial court.
Okay. Heard Mr. S. Nawaz, learned counsel for the appellant. Poster. The instant appeal is under section 378 within bracket 4 of the Code of Criminal Procedure 1973, comma, presently, comma, what is the
Presently, 419 subsection 4.
section 419
Nine.
within bracket 4
4.
of the Bharatiya Nagorik Surakha Honita 2023 against a judgment dated 22/03/2024 passed by the Court of Learned Chief Judicial Magistrate Gwalpara in NI case number 06/2018 post up. In NI case number 06/2018, comma, the present appellant was the complainant who instituted the complaint for the offense under section 138 of the Negotiable Instrument Act 1881, comma, as amended, post up. The learned trial court, the learned trial court by the judgment dated 24/3/2024 has acquitted the respondent herein, comma, who was arraigned as the accused herein, full stop. The special leave to appeal has already been granted by an order dated 7/2/2025 by this court in criminal petition number 17/2024 full stop. This court has gone through the grounds urged in a memorandum of appeal. The appeal is admitted for hearing. Case records of so will be called for issue notice returnable in 4 weeks. The appellant shall take steps for service of notice upon the respondent by registered post with AD as well as by usual process within 3 working days from today.
Deeply appreciated.
Time being better. Item number 3.
Yes, Mukta, it is an interesting one. Will yes.
We'll file reply there, my lord.
So far, what I found from going by the section, my lord, and regarding this case, my lord, perhaps, my lord, in this case, it has not been stated how the judgment, my lord, order is perverse, my lord, because only
order is not perverse.
Yes.
The question is that is why order is not perverse.
Perverse, my lord.
Because it is absolutely in conformity with the provisions.
Yes, my lord.
My issue is that he can very well avail the opportunity of hearing provided under the proviso to subsection 1 of section 223 and argue the case that yes, even by reading of the complaint, no case is made out for taking cognizance. Right? If any order is passed thereafter by the trial court, After hearing the complainant and this side, and that let us take cognizance.
Yes.
Then there will be second opportunity for the petitioner
Yes.
to approach this court. Under code 5. Yes, you will have two opportunities. Now, why you are jumping the gun?
Yes.
That court might not take cognizance in view of all these allegation of mesmerization or something.
Yes.
Right?
Yes.
That is why I said that why we should, because if we give indulgence of this petition, this kind of petition, then this court will be flooded with this kind of petition. When you have the equal opportunity to argue the matter before the trial court, that is what I say.
And
I'll observe that petitioner is withdrawing this petition in order to avail the opportunity of being heard under the proviso to so and so. At this stage, you are withdrawing. Right?
Yes.
You will have another opportunity to come.
Yes.
But if the thing is closed there, what should do is waste our time.
Yes. That is the intention of the exactly.
That is perhaps the intention of the legislature now. This is the
fully agree, my
lord. Shift in the BNSS.
Yes.
The language, Lordship finds the language is very clear. My lord,
Very clear.
Earlier, my lord, it is stated that issue of
only difference between 204 or 204 perhaps
23
and 223 is that inclusion of this proviso.
Yes, and another, I have, my lord, if your lordship permit, if in the opinion of a magistrate taking cognizance, this is the earlier, my lord, 204, my lord. Now, my lord, is magistrate while taking cognizance.
Yes.
This part is, that is the difference, my lord.
Heard Mr. S. Mukhtar.
And
Then
some of
also for the
the
petitioner.
rulings, latest rulings, I have some of find out, my I will give the, so for your lordship's perusal, my lord.
You keep a compilation
Lordship.
ready with you.
Lordship.
I think Supreme Court has not yet rendered any.
Lordship, there is a, yes, pending before a petition has been pending, my
That is PMLA
yes.
for the petitioners. And Mr. MP Goswami learned, oh, you're not there.
Lordship,
Post of. After hearing the learned counsel for the petitioner was at some length, comma, after hearing Mr. Mukhtar, learned counsel for the petitioner at some length, comma, Mr. Mukhtar has submitted that the petitioner would avail the opportunity being heard provided on a given in the proviso, in the first proviso to subsection 1 of section 223 of the Bharatiya Nagorik Suraksha Sanhita, 2023 before the court where the complaint case
551,
number 551 cross C stroke 2024 is pending. Want to exhaust the remedy of being opportunity being heard. No?
Yes.
In view of such submission made by the learned counsel for the petitioner, this criminal petition is closed up, reserving the liberty to the petitioners to exhaust the remedy of the opportunity of being heard provided by the proviso to subsection, first proviso to subsection 1 of section 223 of the BNSS before the court of
Judicial Magistrate First Class.
Judicial Magistrate First Class.
Kamrup, Metro Guwahati.
In response to the notice issued to the petitioners by order dated
9/7/25.
9/7/2025.
Obliged.
Item 16.
Jail. Okay. This criminal appeal from jail. Is against a judgment dated 18 to 2025. And an order on sentence dated 20/02/2025 passed by the Court of Sessions Judge, Kibahaga Trial Court, in Sessions case number 99 within bracket S-N bracket close of 2023. By the judgment date and order on sentence dated comma. The accused appellant has been convicted for the offense under section 304, part 1 of the Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹6,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. Post of the appeal is admitted for hearing. The case records of so-and-so be called for. Issue notice returnable in 4 weeks. As Mr. MP Goswami, an additional public prosecutor, has appeared and extracted notice on behalf of the respondent state, issuance of formal notice to the state, to the respondent state is dispensed with. Post of panel. Panel assigning single ones. Yes, Mr. Goswami propose. Okay, these are okay. Nimis Mahajan from the council from the panel of legal. Oh, there are দুটা seat আছে নেকি? একটা legal aid from the panel of amicus curiae to represent the accused appellant. Post of the name of so-and-so be reflected in the cause this post of the office to furnish the necessary case papers to Mr. So-and-so within 2 weeks from today. Nimis Mahajan.
Yes.
Already I named. So keep a list of amicus curiae, and there are one more list. I think list of all panel lawyers. Oh no, panel lawyers. Find out from this panel lawyers, Guwahati High Court Legal Services Committee. If you are enlisted for criminal, if you are civil, so find out the criminal who have been assigned for criminal matters. Then keep it with you so that we can go serially one by one. So that nobody gets more and nobody should be left out. Right?
Item 17.
Everybody should get equal opportunity.
May it please your lordship. Your lordship, this is a jail appeal. Your
Jail
lordship.
appeal.
Yes, your lordship.
Okay, you are already appointed.
Yes, your
Okay,
lordship.
Miss.
M.K. Brown.
Okay. Heard Miss M.K. Brown, learned counsel for the accused appellant, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent state. Offense 302 or POCSO?
POCSO, your
Okay. This criminal appeal is preferred against a judgment and order dated 30/9/2024 passed by the Court of Learned Special Judge POCSO at Golaghat Special Court in Special POCSO case number 50/2021, which arose out of Dergaon Police Station case number 188/2021, posted by the judgment and order dated so and so, the accused appellant has been convicted for the offenses under section 363, IPC and section 6, protection of children so and so. For the offense under section 363, IPC, the accused appellant has been sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 5,000, with default stipulation. For the offense under section. Oh, this is 20 years
Yes, your lordship.
before division means. For a period of 20 years and to pay a fine of rupees 10,000, with default stipulation. Para. As the sentences are ordered to run concurrently. Para. As the period of imprisonment is more than 10 years, this court is of the considered view that the appeal is to be listed before a division bench, the office to verify the matter and thereafter list the appeal before the appropriate bench.
Obliged.
Above 10 years, division bench.
Item 18.
This criminal appeal from jail. Let me check before passing the order. This is 10 years. Can be admitted. Okay.
Problem is that we don't have the.
Okay. Now I have to check now from jail is against a judgment an order judgment judgment dated 27/2025 and an order on sentence dated 28/2025 passed by the Court of Learned Special Judge POCSO Nagaon Special Court in special (POCSO) case number 01 capital N of 2024, which arose out of Samoguri Police Station case number 294/2023. Post up by the judgment and the order on sentence, the accused appellant has been convicted for the offense under section 4 of the POCSO Act, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 50,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. First of the criminal appeal is admitted for hearing. Case records we call for issue notice returnable in 4 weeks as Mr. MP Gussamil and additional public prosecutor has appeared and accepted notice on behalf of the respondent state, issuance of formal notice to the state respondent is dispensed with. Post office to take steps for service of notice upon the respondent less informant in terms of the practice direction. The additional public prosecutor is to obtain a report as regards service of notice upon the respondent informant from the officer in charge Samaguri police station and to place the same before this court on the returnable date.
Item 19.
This criminal from jail. Oh, sorry, appointment. Appointment. Next. Tapan Ranjan Deuri. Agonis na? Etudli. Judgment and order dated 9/4/2025. Passed by the Court of Special Judge Udin Maker Additional Dhuri in special case number 3 of 2023. Convicted under section 22 within bracket small c NDPS Act, and he has been sentenced to undergo rigorous imprisonment for a period of 10 years and to pay a fine of rupees 1 lakh, in default of payment of fine, to undergo rigorous imprisonment for another year. Admitted for hearing. KSI courts issued notice. Returnable 4 weeks. Mr. MP Gusami. Next. Any NDPS specialist from here? From the list. Okay. You are
Not a specialist, my lord.
Sarfaraz. Nawaz.
Item 21.
Section 12 POCSO conviction.
POCSO.
Yes, Your Lordship.
Mr. B.J. Mukherjee, counsel for the petition by the judgment. An order dated so and so. The accused appellants have been convicted for the offenses under section 304 part 2, stroke 308 stroke 323 of the IPC read with section 34 IPC for the offense under section 304 part 2 IPC read with section 34 IPC. All the accused appellants.
1, 2, and 4, my lord, 7 years. And 3, pillar number 3 is 3 years.
Okay, the accused.
Pillar number 1, 2, and 4 is 7 years. And pillar number 3 is.
Where it is?
My lord, in judgment, my lord. It's 56. And it's 56.
Okay. The accused appellant number one, 2, and 4 have been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 20,000 each, in default to make payment of fine, to suffer further rigorous imprisonment for 60 days each. Full stop. The accused appellant. Number 3. Has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 20,000, in default to make payment of fine, to undergo further rigorous imprisonment for 60 days under section 304 part 2 IPC read with section 34 IPC. How can it be? If it is with 34,
But
all are equal.
all are equal.
How can one be picked up? If 34, what is the 34? All are same, cannot be distinguished. If the 34 is attracted, all are equally liable for the offense under section 304, 308. IPC read with section 34 IPC. The accused appellants, all the accused appellants have been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 10,000 each, with default stipulation. Full stop. The sentences are ordered to run concurrently. So 34. In the same manner, as if it were done by him alone.
Yes.
If somebody out of all 4 have murdered or committed culpable homicide, not amounting to murder, all are equally liable. We'll issue notice at this stage then. In IA. Are you on bail?
My lord,
1, 2, and 4 cannot be on bail.
my lord, so far, accused number 3 is bail, but 3 conviction is bail, my lord.
Something very wrong.
In fact, my lord, going by the statement I have gone through roughly, all are equally involved. My lord.
No,
Even otherwise,
all are equally. That
but 34 is there.
law, by law,
Yes,
operation of section 34.
same manner.
In the same manner as if he had done.
Yes, madam.
So out of 4, suppose A1 had done it.
Madam.
If the common intention is there, then A3 is equally liable.
Equally liable.
There cannot be different sentence for A3. Tell me on it.
My lord, the judgment, my
Ah.
lord, the position I have gone through, my lord, there is some discrepancy is there, my lord.
No, that discrimination is different thing. We are on law, point of law. You
I am not, it's
because if we issue notice on 1, 2, and 4, there should have been separate applications.
separate, my lord, one for extension.
Separate applications.
Yes, my lord. Two
Or 3 separate.
separate, my lord.
You should have filed. Otherwise, if I go and record, then I'll record 34. Palpably wrong order.
IA to only separate position.
Separate.
IA he has filed
I
separate.
separate, my lord, 2 IA, my lord.
2 IA.
Okay, good.
87.
Rukia Bibi.
Yes, my lord.
Lekok, Mr. H. Ali. Learned counsel for the applicant appellant. And Mr. R. Kosik. Learned additional public prosecutor for the opposite party, that's respondent state. The instant application under section 430, we didn't get 2, is preferred by the applicant appellant, seeking suspension of execution of the sentence passed against her and for her release on bail. Post of the applicant as the appellant has preferred the accompanying criminal appeal number 302/2025 against a judgment and order The applicant appellant has been convicted for the offenses under section so and so, read with section 34 IPC, huh? For the offense under so and so, likibo. Art add kori dibo tar logot. Art ase to. For the offense under section 323, IPC, read with section 34 IPC. The applicant appellant has been sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 10,000, which default stipulation. All the sentences are ordered to run concurrently. Post up. Where Mr. Ali, learned counsel for the applicant appellant, has submitted that the trial court has urged to confer common intention on the part of the applicant appellant, as the trial court was not fully convinced as regards presence of common intention, rigors of sentence has been sentence passed under section 304 part 2 IPC has been relaxed in the case of the applicant appellant. Post up. Mr. Goswami, learned additional public prosecutor, has submitted that if the applicant appellant has been convicted for the offense under section 304 part 2 IPC in aid of section 34 IPC, then, as per law, each of the persons is liable for the act in the same manner as if the act were done by him/her alone. Full stop. Para. Be that as it may, the applicant appellant is found sentenced to undergo rigorous imprisonment for sentence to undergo imprisonment of 3 years for the offenses under section 304 part 2 34 and section 308 IPC in aid of section 34 IPC. Post stop. Perhaps at A 3678 Bosmundra Grisil. Like 20,000 press bill, huh? Press bill with 1 COT. Heard Mr. H. Ali, learned counsel for the appellants, 3 applicant appellants herein, and Mr. R. Kosik. The instant application under section 430 within bracket 2 of the BNSS is preferred by the three applicants appellants seeking suspension of the execution of the sentences passed against them and for their release on bail, issue notice returnable in 4 weeks. Steps extra as Mr. R.R. Kushik has appeared accepted notice on behalf of the opposite parties. The respondents state issuance of formal notice to the state respondents dispense with list returnable without a returnable on a particular date. On a particular date. Admitted. Returnable date of that.
10 September, 10/9. '29.
May it please your lordship. 528 application. Original case, my lord, was under section 138 NI Act, my lord. In that case, my lord, cognizance was taken. I was the complainant in that case, my lord. Cognizance was taken.
You are the complainant. This petitioner is the complainant.
Petitioner is the complainant. So in the 138 case, my lord, the respondent appeared. Offences were explained to the respondent. Subsequently, my lord, talks of compromise were initiated between the two parties. To a certain extent, when the respondent even appeared before the court and said that I need some time to pay the money. Thereafter, my lord, a petition was filed by the complainant saying that since the complainant accused has already agreed to pay the money, the case may be disposed of with a direction to him to pay the money. That was in terms of a circular issued by this honorable court. That was a wrong interpretation on the part of the complainant, my lord. Be that as it may, that petition was rejected. So now on the next 3 dates, my lord, the complainant remained absent without steps. And then the complaint was dismissed for default, my lord. Now, we preferred a revision against that dismissal order, my lord. And that revision was also, my lord, dismissed, saying that we could not substantiate why we were absent on 3 dates, my lord. So we could not justify our absence, my lord. So the revision was also dismissed.
You preferred?
A revision, my lord. Now, earlier, my lord, there was a concept that if it's a complaint case which is dismissed on default, it would amount to an acquittal under 256. But now the Honorable Supreme Court has clarified, judgment has come on that point, that it is only when the case is fixed for appearance of the accused. And the second part of 256, when it says that any subsequent day thereto, that is also in the context of appearance, my lord. So if a complaint case is dismissed during appearance of the accused person, only then 256 will come up. Otherwise, 256 will not come up. So an order of acquittal cannot be read into such dismissal.
To me, that
my lord. Because earlier the law was that, my lord, any complaint, if it is dismissed, it would be deemed to be a dismissal under 256. But this judgment, my lord, will kindly see Ranjit Sarkar versus Ravi Ganesh Bharadwaj, my lord, 2025, SCC online, SC 680. Your lordship will kindly come to paragraph 17, my lord. 19 is the decisive paragraph, but from 17, my lord, it is relevant, my lord. May I read, my lord, from 17? The next error that the learned judge committed arises from a failure to consider the law in the proper perspective, as well as the weight of the observation made by the High Court in the earlier order dated so-and-so. The complaint case was listed on 16 April 2021 before the judicial magistrate for a limited purpose. That is, cause to be shown by the appellant as to why, for his absence, the complaint should not be dismissed for default. On that day, even the respondents were absent. Overlooking these, the learned judge placed undue reliance on the order dated 19 September 21, as if the observation contained therein on interpretation of 256 CRPC was the final word and binding on all, notwithstanding the remedies that law provided to the appellant to challenge the order of dismissal for default. The law permitted the appellant to question the order of dismissal dated 16 April 2021, which he did question. We are minded to observe in the light of the subsequent judicial proceedings and order passed therein that the learned judge who had the occasion to consider so-and-so would have done better if so-and-so were disposed of merely recording that nothing survived for decision on the challenge to the summons in view of dismissal of the complainant for default. Instead, the learned judge went to make an observation with regard to what would be the proper interpretation of 256 CRPC for the outcome of the complaint case in favor of the accused, arising out of non-appearance of the complainant, which, apart from being wholly unwarranted, has resulted in unnecessary proceedings which were wholly avoidable.
Even otherwise, such observation was patently incorrect, since bare reading of section 256 CRPC, having regard to the attending facts and circumstances, did not entail an acquittal for the respondents, as we presently propose to demonstrate. Significantly, the learned judge seized of CR so-and-so interfered with the impugned revisional order merely because of such previous observation without any proper application of mind. Chapter 20 of the CRPC is titled Trial of Summons Cases by Magistrate. It has 8 sections from section 251 to 259. Section 254 lays down the procedure to be followed if conviction is not recorded in terms of sections 252 and 253. An acquittal can be recorded by a magistrate under section 255 CRPC if, considering the evidence, it is found that the accused is not guilty. An acquittal can also be recorded by the magistrate under section 256 CRPC without considering the evidence on record in the stated situations. Section 256 of the CRPC reads as follows. Non-appearance or death of complainant. If summons has been issued on complaint and the day appointed for the appearance of the accused or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused, unless for some reason he thinks it proper to adjourn the hearing of the case to some other day, provided that where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. The provisions of subsection 1 shall, so far as may be, apply also to cases where the non-appearance of the complainant is due to his death. What therefore assumes importance for invoking section 256 CRPC is the purpose for which the case is fixed. If the date is not like in the present case, if the date is not appointed for appearance of the accused, but for some other purpose, like in the present case, acquittal of the accused does not necessarily follow as the logical result of absence of the complainant. Also, the words on any subsequent thereto must be understood in reference to the words preceding, namely the day appointed for appearance of the accused. Say, for instance, if a date is fixed for the magistrate for bringing an order from a superior court or for showing cause why an order of dismissal should not be passed for continuous absence of the complainant, or for producing any material which is not intrinsically connected with any step towards progress of the list, and the complainant is found to be absent, a dismissal of the complaint can be ordered. But the provision for acquitting the accused may not be attracted unless it happens to be the date appointed for appearance of the accused, and they do appear personally or through an advocate. Also, without a magistrate recording a clear acquittal along with the order of dismissal of the complaint, acquittal need not be read into every such order of dismissal of a complaint owing to absence of the complainant. So, in terms of this judgment, if a complaint gets dismissed on default and it is not fixed for appearance of the accused, as it was the case here in my lord, acquittal under 256 cannot be read into the order.
What is the order?
My lord will first, my lord, dismissal order is at page 52, my lord. Prior to this dismissal, my lord, the case was fixed for cross-examination of the, before the complainant stopped appearing, it was fixed for cross-examination. The lordship starts from page 22 onwards. I have given the orders, my lord, just to show the.
Yes, then in the revision, what was the?
Revision, my lord, your lordship will kindly come to page 53, my lord. And relevant portions, my lord, the discussion starts from page 61, my lord. Para 11 onwards, my lord. May I read, my lord?
1 minute. What are the two orders? 222(8)
Order was, my lord, regarding that when we filed that application for disposing of the case, my lord, on the basis of their statement that.
What are the orders? Why is page 60?
My lord, page 60, my lord, giving both orders, my lord. Page 60 order, first order is.
Page 60, that point for determination.
Yes, my lord. There are two orders, my lord. In
Let us see
revision,
that
we have
order.
challenged two orders, my lord. First order that was challenged in revision was the order which is at page 46.
Page 46.
That was the order, my lord. That is apparently, my lord, that finding is correct, my lord. That
Represent the accused person is absent. Yes, that is the one order.
There is one order. The second order is the dismissal order, my lord. Here, my lord, we are not impugning this order, only the dismissal order.
Is there no precedent on 256, section 256?
There was earlier, my lord, because there was another judgment earlier, but I also have that judgment. But there was no discussions as such on 256. My lord, will kindly have this judgment.
Because prosecution ends with the dismissal of the complaint, right? There are three sets of procedures: summons procedure, warrant procedure, and sessions. Let us take the example of warrant procedure and summons procedure. And suppose warrant procedure instituted otherwise than police report,
Complaint.
there is scope for dismissal also.
My lord.
If that case ends in dismissal for non-prosecution, what happens to the accused? Because the logic, I'm not finding very convincing logic here. Let us learn by that way. That let us see warrant procedure in a CRPC, because I am more conversant. Then we'll shift to BNSS.
Here, perhaps, my lord,
1 minute.
CRPC.
1 minute. CRPC. Let us have the
My lord,
CRPC.
its warrant procedure starts from 238, my lord, chapter 19.
Warrant and otherwise than police report.
That starts from, my lord, 244, my lord. There is one provision for absence of complainant in warrant procedure, that is in 249.
249.
But again, it is, my lord, confined only to cases which may be lawfully compounded or not a cognizable offense, or non-cog and compoundable offense. May I make one submission, ma'am?
Yes.
Your lordship will see, even if it is a summons case or warrant case or a sessions case. Well, sessions case obviously my lord cannot be on a complaint. Warrant case or summons case, there is no provision for as such for dismissal for default, my lord. Two enabling provisions are 249. Even 249 speaks of a stage which is before framing of charge. And it is for if the offences are compoundable or non-cognizable. Before framing of charge, if the complainant stops appearing, my lord, then the court can discharge the accused. In 256 also, my lord, in terms of the judgment I am submitting, my lord, if it is before the commencement of the trial, at that stage, my lord, the court can dispose of the case. But neither the chapter 19 nor chapter 20, my lord, contemplates any stage where after the commencement of the trial, which is with the explanation of the offense, my lord, or the framing of the charge, a case can be dismissed for default, my lord. But obviously, my lord, where complainants have not appeared routinely, my lord, cases have got dismissed for default. Now, before the judgment came, whenever a complaint case in a summons case was dismissed for default, it was always understood that this is a dismissal under 256. So
I am worried about interpretation. I am not
Yes,
that. I am worried about whether this judgment could be per imperium.
because there's only one judgment, my lord, I have found in the Honorable Supreme Court. That, your lordship, I have the judgment also, my lord. This is a case, my lord, where this 256 acquittal part had been discussed, but there is no discussion as such. The lordship will kindly come to para 6.
What is the order? What is the order? Dismissing.
Dismissal order, my lord, page 52, my lord.
Page?
52, my lord.
So this is the reason, there is reasoning.
Reason is there, my lord.
There is reasoning. So, and it was for what purpose?
The case was initially fixed for, my
For
lord,
what purpose?
cross-examination, my lord. Page 47, my lord.
It was requirement of the complainant was there on that
Yes,
day,
yes, my lord.
right?
Yes.
It is not that it is only for the appearance of the accused.
No, my lord.
Requirement of the complaint was there.
Was there, my lord.
So complaint was found absent on for how many occasions?
3 occasions, my lord.
Because it is also laced with a condition, other precedents.
My lord.
It is also laced with a condition of Article 21 of the
My
Constitution.
lord.
It is not that only the sole prerogative of the complainant. Right. The other laws, other precedents
My lord.
are there that it is also laced with the right to speedy trial on the part of the accused. Right.
Yes, my lord.
But it is not a one-sided story.
Yes, ma'am.
Always. It is two sides of the coin. Both are to be looked into. Now let us see how many occasions.
My lord will kindly start from that.
Now let us see the orders, previous orders.
Yes, my lord. Starts from page 22, my lord.
Page
22.
22.
22, my lord. Giving the entire chronology as to how many dates were taken by.
47 it will do, Lordship. Because the absence started from page number 48.
No, let
The
us
entire
see.
chronology, my lord, will kindly see. From page 22.
As file evidence on affidavit.
Here, my lord, cognizance is taken on, my lord, 25/10/2017. Then, my lord, will kindly come to
Where is the entry of the accused?
accused, my lord. Offense is explained in page 24. Offense is explained on 2018, my lord. Then, my lord, will kindly see at page 26 from 2022 onwards, my lord, I've given all the orders. From 24/5/2022. Here, learned counsel for both sides have also already submitted before the court that there is a scope for amicable settlement as compromise talk is going on between the parties. Next date is 28/6, my lord. Then next, my lord, page 27/18/8. Again, both parties, my lord, submit that talk of compromise is going on between both the parties. And then again, my lord, next 2 dates, my lord. First date, both are absent. Next date, complainant is present, accused is absent. Then on the next date, both sides are present, but court did not pass any order, my lord. Then on page 28, my lord, accused files petition saying that he needs some time to arrange the money. And there is a talk of compromise going on between the parties. That is why he's praying for some time. Petition is allowed for the last time. Now, my lord, will kindly come to the next order. Again, my lord, adjournment is taken. Again, this time again, it is allowed for the last time. Thereafter, my lord, it is 17. Thereafter, my lord, in terms of the circular, then my lord will come to page 39. We filed this petition, my lord, in terms of the High Court circular, my lord. And the order is at page 19/4.
Circular. What kind of circular is it?
Circular, my lord, there was it starts from page 34, my lord. Your lordship will kindly come to page 36. Clause 2, my lord. Some practice directions were given. And clause 2, my lord, it says that it shall be explained to the accused person that if he intends to make an application expressing his desire to remit payment against a dishonored check in terms of the guidelines laid down by the Honorable Supreme Court in so-and-so case, he can do so by making an application. If such an application is made by the accused person, the court shall, in presence of the complainant, consider the same in terms of the said guidelines and shall dispose of the case if the application is found to be in conformity with the guidelines. Based on the understanding of this clause, my lord, we filed a petition saying that since he had already agreed to pay the money, case can be disposed of with a direction to him to pay the money. Then at page 41, my lord, based on this petition, the case is fixed for
page 34. So this particular page 36.
Yes, my lord.
To make an application is desire. Expressing his desire to remit payment in terms of the so we can do so by making an application. As they will consider in terms of the signal and the application is found. Is there anything wrong here in this clause?
No, my lord. That is the law laid down in Babulal case, my lord. Here they had not made any application. They had only orally submitted that they needed some
Because
time.
I understand, because I was the author of this one, that is why. Now I remember I was the author of this one, yes.
So, my lord, they did not make any application. They just orally submitted in court that we needed some
Oh,
time to-
going on.
Going on. And they
Going
said,
on.
we-
That is not finality.
finality. But based on this erroneous understanding on our part, my lord, we filed that petition.
Then thereafter what happened?
Page 41, my lord, based on this petition, court fixes the case on
Page?
41, my lord. Second paragraph, your lordship will see.
In the petition.
Court fixes it for hearing, my lord. Next day, my lord, heard both sides, fix for orders. Next day, my lord, the presiding officer was on leave. Lordship has page 42, my lord. Presiding officer was on leave. On the next day also, my lord, the learned court did not pass any orders.
28.
Yes, my lord. Then finally on 46, the order is passed rejecting my petition, my lord.
Okay.
And the case is fixed for cross-examination. Thereafter, I default, my lord, on 3 days. The delay, my lord, only is not only attributable to me, my lord. My default is there, my lord.
One, two. Two.
Yes. So hearing this case, the
The
default on
stage of cross-examination of the witness,
Started from 20
complainant arrived
24/5
only after this date.
24/5/22 lordship, page number 26.
No, it's the stage for cross-examination
Of complainant
of the complainant has
26.
arrived only after 22/8/2023.
No, lordship, 26, page number 26.
Page 26, yes, my lord. 24/5/22.
24/5/22.
24/5.
22. Then 28/6/22. Again, the matter was fixed for cross-examination of complainant.
The 2 dates.
Yes.
Thereafter again,
Again on 13/12/22 lordship, this fixed for
18/8
for necessary
2022,
order.
the situation changed.
Yes, to
for
some extent.
compromise.
Exactly, lordship.
Right?
Yes. Considering
Thereafter
the
it went on like that.
then cross of PW on 13/12 lordship. 13/12/22. The next date was fixed on 11/1/23 for cross of PW.
Which page you were reading?
Is I'm just on 27 lordship, the last order.
Steps taken. Well, no, question is, accused is present. Complaint is absent. On 24/5/2022, complaint was absent.
Yes.
28/6,
Complainant
Complainant was absent.
absent.
On 13/12, it was complainant was present.
Even on
Accused was absent.
Absent.
even on
Right.
18/8, my lord, both
Yes.
sides were present.
18, therefore the situation changed.
Changes, my lord.
The talk of compromise story started cooking, right?
Yes.
Thereafter, all these dates except 13/12/2022, complainant was present, accused was absent, right?
Yes.
Thereafter, all necessary orders. Then again, 17 to 2023, complainant was present, accused was absent. Right?
Yes.
Page 29.
29.
Then the order was passed on 22/8/23. Page number 46, Lordship.
We're going to 46.
Yes.
We are examining conduct of both the parties.
Exactly, Lordship.
Then which page?
41, my lord.
41.
Both are present.
41. This is regarding hearing.
This is hearing.
On that, the case was not fixed for cross-examination.
No.
Then also 7/6 not.
Necessary.
Then 20/07. Same.
Same.
For necessary order.
Necessary order.
Then 14/8 also.
Yes, ma'am.
It went on like that.
22/8.
Then 22/8 it was decided ultimately regarding talk of compromise.
Yes.
Then again it was fixed for cross.
Cross.
Right?
Yes.
Then this is the so the next date was
1910.
1910. That's the first occasion.
Yes.
Next was 28/12/2023. Second occasion.
Yes, ma'am.
On the third occasion, it was disallowed. Right? Dismissed.
Dismissed.
It was dismissed. Third occasion. Otherwise, prior to that, story was similar. One day, one was absent, the other was absent.
No, with regard to cross, Lordship, at the time of cross-examination of the
seen.
complainant, yes.
I have seen. Now, if
Yeah.
you go on counting, then let us count. But prior to this order,
Yes, Lordship.
at page 46, prior to that order in page 46,
Yes.
previous part, orders it looks like similar. Complainant is present, accused is absent. Accused is present, complainant is absent.
But the stage was not similar at that point of time. Stage was not similar because the complainant was
Stage was
absent during the
similar.
time of cross-examination of the complainant.
You have both agreed to this talk of
Exactly,
compromise.
Lordship.
It went on ultimately 28
Yes, Lordship.
2023.
I'm
The
just
third-
referring to page number 26. These two dates, the complainant was absent. Page number 26, Lordship, that was on 24/5/2022.
Those are gone, those
Yes.
are gone days.
Yes,
If
Lordship.
you want to count again, then let us count then.
No, I'm saying that during the period of the cross-examination of the complainant, he was absent during that relevant period of time. And subsequent absence of the accused was
It was
Exactly.
because cross-examination can be done by the counsel also in the absence of the accused.
the complainant, Lordship. Complainant was
Sorry,
absent.
in
Yes,
the absence of the accused.
yes,
The stage was set for cross-examination. Right?
yes.
If the complainant is present, then cross-examination can be done
Exactly.
even in the absence of the
Exactly, Lordship.
accused.
There is no
right?
requirement of that.
Right?
Yes,
So let us page 26. On
Yes.
that day, complainant was absent. On both the dates, 24/5
and 28/6.
28/6. Both are on both those dates, complainant was absent with
Absent.
steps. So it is not possible for accused to cross-examine.
Cross-examine.
Then if you come to page 27,
13/12.
13/12,
Yes.
complainant was present, accused was absent, showing cause.
Yes. But that was not
And there
fixed
was,
for
I
cross-examination.
think, Liberty was not asked also to.
No, Lordship, that date was not fixed for cross-examination because if
NO.
you go by the one, yes, Lordship.
So
Yeah, no.
accused can be. It was not.
It was not fixed for cross-examination, Lordship. That
So-
was for NO.
Right.
Yes.
So you are fair. Now, this is also page 29.
28 is there also.
No, these are all for NO.
Because
NSI order.
all are NO.
All are NO.
11.1 was for cross of PW, my lord.
Uh-huh.
Last order, your lordship will see 13.12.
Which page?
Page 27, last
27.
order.
Huh?
6 for cross. On the next day, both parties were present, but put
Somehow.
again 6 for NO.
Somehow nothing was there for necessary order.
Necessary order.
So this nothing can be attributed to any of them.
Exactly, lordship.
So if you go by that, then it is the third occasion. It was the third occasion
Third
when the
occasion.
court decided to close the proceeding, dismissal for non-prosecution.
And the revisional court rejected the prayer of the
On what
petition.
ground?
Yes, lordship. It is that the
Starts from
operative portion is at page number 63, page number 16, with regard to the legality of the order, the impugn order. Paragraph number 16. I'm just reading that paragraph 16, lordship. Now coming to the legality and propriety of the yes, order dated 23/2024. After going through the case record, it appears that prior to 23/2024, 2 dates are fixed by the learned trial court for evidence, that is on 19/10/2023, and for necessary order on 28/12/2023. And on both the occasion, the complainant remained absent without showing any cause of absence. Accordingly, the learned trial court, as the personal attendance of the complainant seemed to be necessary to face cross-examination, dismissed the complaint under section 256 CRPC. However, learned trial court did not write in its order that the accused is acquitted. Since a complaint lodged under section 200 CRPC, reference is there, lodging. Then the instant revision petition is the last paragraph, lordship, paragraph number 14. Accordingly, finding no merit in the instant revision, the prayer is rejected. The impugn order of the learned trial edition as well as 23/2020 passed in NI case was under section is hereby upheld. Now, before going to that, lordship, in paragraph number 12, it has been specified that since a complaint lodged under section 200 CRPC against an accused can be dismissed, and the accused can be acquitted in absence of the complainant on a date fixed for hearing under section 256 CRPC. I find that due to the absence of the revision petitioner, that is the complainant on the date fixed for hearing, that is on 19/10/2023, made his case liable to be dismissed, and accordingly I find that the learned trial court has made no error in passing the order of dismissal of the complaint in view of the above discussion. So the learned this revisional court came to a finding that there being no reason that has been shown at that point of time when the complainant was absent. No application was filed, nothing of that sort, lordship. Only thing that made a mention that the entry was not there in the diary. So there is nothing like that in the record to show that aspect of the matter also, lordship. In paragraph number 15 of the page number 63, it has been referred by the learned revisional court, that lordship. But now coming to the third ground pleaded by the revisional petitioner, because they took a plea in the revision petition that the entry was not there. It is seen that though the revisionist and petitioner allege that due to non-posting of the case in the diary of the learned counsel.
What is the check amount?
Something.
Take amount is, my lord, 2 lakh rupees, my lord.
What are the dates of default? Earlier 3 dates. Complainant.
Complainant's default, my lord. This one. Complainant's default, my lord, 19/10/2023.
19/10/23.
Then, my lord, 28/12/23.
28/12/2023.
And 23/24.
23/24.
20,
20.
my lord, 20/03/2024. Take amount was 3 lakhs, my lord.
In 10. So it was informed on 22/8/2023 that the case shall proceed in its regular course.
Yes.
And no further adjournment is to be granted to either of the side for cross-examination of the PWs, observing which necessary orders shall be passed. It was forewarned to all of both the parties. Page 47. So what prompted you to be absent for few
We have taken two grounds, my lord, on this, my lord. First is, my lord, on the date when this order was.
You were absent without step.
Without step.
Yes, my lord. That's what is there.
One singular default, it is okay.
My lord.
Three consecutive.
My lord, this default on my part is there, my lord. There is obviously, my lord, that is why my case has been dismissed, my lord. But what I am submitting, my lord, is that, my lord, this delay which has occurred, because this is a case, my lord.
Because see, same logic otherwise, like criminal appeal cannot be dismissed for non-prosecution.
My lord.
But revision petition can be dismissed.
Yes, my lord.
Right.
Yes, my lord.
In this court also,
Yes, ma'am.
law is different. For petition, it can be dismissed. Now, it was the original prosecution. Let us come back to this Ranjit Sarkar again.
My lord.
It cannot, then if this logic is to be applied, then on no dates, the court can dismiss.
Here, my lord, court says that can be
Let us see.
dismissed, but cannot be, it can be dismissed for default, but cannot be acquitted, my lord. That is there, my lord, in page 20, para 20, my lord.
This has been exactly done.
Yes.
Page 52.
Yes, my lord. It can be done, my lord.
Court has not
Acquitted.
proceeded
Yes.
to acquit the
Accused.
Now let us see again, once again, what is the logic again? Which paragraph you read?
No, para 20, my lord. Last paragraph, my lord.
19, let us see.
19, yes, my lord.
What therefore assumes importance for invoking section 256 is the purpose for which the case is. This is from the perspective of
256.
accused also.
Yes, my lord.
Not from the perspective of complainant, perhaps. If I am correct. Perspective of the accused. What therefore is that if the date is not appointed for the appearance of the accused, but for other purpose. It is not appointed. It has made very critical.
My lord.
Situation has become more critical. Now your case is covered otherwise. Dismissal of the comprehensive is paragraph 19.
Yes, my lord.
It is one of the instances.
Yes.
Say, for instance, if a date is fixed.
Yes, my lord. By the magistrate for bringing an order from a superior court.
Or for showing cause.
Why?
when order of dismissal should not be passed for continuous absence of the complaint. Yes, Mr. Ghosh.
Lordship has rightly pointed out with regard to that order dated 22/8/2023.
No,
Page number-
the
yes.
judgment.
Yes. The judgment paragraph 19, yes, it is there, Lordship.
If a date is fixed.
Yes. Yes, sir.
Right, if you
Exactly.
read now.
Yes.
If you read, say for instance,
Say for instance.
if a date is fixed
Yes,
by the magistrate.
magistrate.
Right?
For bringing an order.
Stop, that part stop.
Yes.
You skip that. If a date is fixed by the magistrate, you skip that part, you read after or. For showing cause, when order of dismissal should not be passed for continuous absence of the complainant.
Yes.
This part. Meaning thereby,
Yes.
if you read more carefully, then before dismissal, there has to be a show cause notice.
No, that's why I've just referred to page number 47, Lordship, because that communication was already there, Lordship, because in page number 47, that 22/8/2023.
Page 47.
Yes, Lordship. That has been notified. The last paragraph, the before fixing the date, it is however made clear that no any further adjournments is to be granted to either of the side for cross-examination of the PWs, debating which necessary order shall be passed. So that particular knowledge is very much there with regard to the complainant is concerned, Lordship. Even thereafter, Lordship, there is no application filed, nothing of that sort. For continuous 3 dates, he was absent.
Still one show cause is to be read into perhaps.
No, when the date has been fixed and it has been specified in that particular order that no further
Now, if
this.
this decision is to be seen,
Yes, Lordship.
then
Show cause is there, but this is one form of communication, Lordship, because the complainant was very much there on that particular date. He was knowing that
it has
order
to
has been
be
passed.
after repeated absence. That is the judgment now.
Yes, that I've seen.
That should not be passed for continuous absence of the complainant.
Yes.
Right?
Yes.
It has to be continuous means it has to be more than one.
Yes.
To apply the word continuous, one singular default is not continuous. It has to be more than one. If it is more than one, maybe, I don't know, but perhaps it has to be read into it that show cause notice must be sent to the address of the complainant.
In fact, on that day, my lord, when this order was passed, if your lordship sees page 46.
I have not read it, but this is my tentative view now.
Yes, ma'am. Representative
If
of
this is the
government-
way,
Because on that.
but because there is a proviso also.
Yes, ma'am.
Proviso is going against the complainant.
Ma'am.
256
Proviso.
subsection 1 proviso, it goes against you.
But somehow this judgment, my lord.
Let me read. But this is without citing any precedent.
My lord.
Right?
My lord.
But there must be precedent.
I tried to do some digging, my lord. These are two judgments I found, man.
You dig because if there is other judgment, then it may be par incuriam. Because the proviso is against you.
Yes.
Provided that what a complaint is represented by a pleader or by the officer conducting the prosecution, that is corporate.
Right.
Or whether magistrate is of the opinion that personal attendance of the complainant is not necessary.
Not necessary.
Magistrate may dispense with his attendance and proceed with the trial. Right. And on all these occasions, your presence was necessary because it was fixed for your cross-examination. So magistrate may has the discretion to close.
Yes, ma'am.
3 occasions. Proviso goes against you.
My lord.
Now only because of this judgment, you are having some cause for survival.
Some hope, my.
Some breathing space.
Yes.
Let me find out some judgment in other way, Lordship.
Find
and
out
fix
because
any day in the next week.
There's one more thing.
post them.
Yes.
One thing, my lord, because on this delay is attributed. The first reason for delay was because they initiated
We
a
are,
POCSO compromise.
we are leaving aside all other delays only from 22/8/2023.
Yes.
We are examining the matter.
On
And
the-
the
I was
court
present.
has passed very express order.
Well, on 22/8/23, my lord, I was present. So when the judgment says that if there is continuous delay on my part, the show cause to be issued, So continuous.
No, we
delay-
are, that is not there. We are trying
My
to
lord.
inject into
My
it.
lord. If your lordship, in a beneficial way, because at the end of the day, when this is a complainant who is seeking to
Beneficial way, more tilted towards accused.
here, this is a case where one of the accused had come forward and said that they intended to compromise the case. They, in fact, to the extent they even said that we are willing to remit money.
Okay, otherwise maybe this, but whether this is applicable or not.
This is a very new judgment. In fact, when I was preparing this, initially I was preparing for a 378-4 minor.
Right.
And then I found the judgment so much.
Right. This is also, this has caught me also by surprise.
This is from March of this year, minor.
I have to go through the reasoning once again.
My lord.
But it is slightly tilted towards the complainant. So make it next Tuesday.
She will keep it as part of, my lord.
Are we there? No change.
Next week.
A couple of cases has happened, my lord. Lordship speaks, my lord, it has
What
been
to
posted
do?
elsewhere, my lord. If your lordship keeps it part, then when
No, we cannot go on keeping part out also.
Get the same benefit if you want to take the deadline.
Okay, Friday. Friday?
This
Friday?
This Friday is holiday law.
Holiday, my lord.
holiday.
Next Friday.
Next week, my lord.
Next week I'll be there.
My lord.
Next week Friday. I'll be-
Tuesday. Tuesday.
Yes.
See whether you can come out anything.
Exactly, Lordship. I will try.
Ah,
I will try.
carving any exception, otherwise this goes in his favor.
There's a High Court judgment also, my lord, but because the Supreme Court judgment was there, I did not bring that. In same line, my lord.
High Court judgment
This
of
one
which
of High
one? Huh? Okay, as Nawaz petitioner. SP. SP. Chaudhary. For respondent number 2. Respondent. With the
Respondent on
case
sole respondent.
on so and so for part A hearing.
Deeply obliged, my lord.
But this will change the scenario. Long set out scenario.
Earlier, my lord, in fact, we had done the same thing, my lord, when complainant was absent, dismissal and acquittal was getting in our orders.
Because the acquittal is necessary corollary for the reason that warrant procedure case and sessions procedure case, it is always discharge. In case of discharge,
Yes, ma'am.
there can be subsequent proceeding also. But in case of acquittal, because there is no charge in summons procedure case, it is only explanation. It is acquittal, it cannot be discharged.
And
But
300
this
will come.
reasoning has been now changed as the entire scenario.
Then 300
Because the other laws are otherwise there, that in case of discharge, it can be revived.
Revive, my lord.
It is not acquittal.
My lord.
But this scenario has, this judgment has changed the scenario. Those are not discussed.
My lord.
Because it is a long line of decisions. In
Consequences
case
will
of
follow.
discharge, it can be revived. In case of acquittal, the proceeding cannot be revived.
Yes, ma'am.
But this judgment has changed the scenario. That is why I am
My lord.
taking my time now.
Deeply obliged.
Item 30.
Yes, sir.
My lord, I have filed an additional affidavit by
1
anything
minute.
some
1
documents.
minute, 1 minute. Yes.
The petitioner's brother was killed, my lord. Inquiry report says he was
Final report was submitted
submitted.
on 28/9/2022.
My lord.
According to your criminal petition,
My lord.
right? And there was a gap.
Gap.
And you are supposed to explain the gap.
Gap.
Let us see your additional affidavit.
My lord. I have filed. From page number 57 onwards, my lord.
Page number or page?
Page 57. This is one of the complaint dated 23/3/2023.
57. What is this?
57 from my lord, additional affidavit, my lord.
57, I have seen.
My lord, this affidavit, this complaint, my lord, filed by the Jonathan Burrow, present petitioner, against the wife of the deceased, Shevali Das, my lord.
The story goes like this, perhaps, Mr. Ali.
My lord.
If I have reproduced it correctly in the previous order, that you are Jonathan Besburua, right?
Jonathan Burrow.
Then you file your brother. What was his name?
My lord, this Satrajyoti Burrow, my lord. Satrajyoti Burrow. Satrajyoti Burrow.
Where is your first complaint?
First complaint, my lord, in my criminal
FIR.
criminal petition page number
Page 9.
9, my lord.
Satrajyoti Burua.
Yes.
Right?
My
And Satrajyoti Burua has a wife. Right?
Satrajyoti Burrow has a wife.
So he had a wife. His name of his wife?
Shevali Das.
Shevali. Okay. Then on 5/8/2022 or 14/8.
14.
Whatever. 14/8 perhaps. Accident was of 5/8. Right? You filed an FIR on 14/8. Page 14. Page 14 of your petition.
Yes.
Right? And according to you, and the driver, Nirmal Borua, was the driver. And because of his negligence, the accident occurred. Right? This is your case? Initially.
Yes.
Initially. Don't jump. Then where is the final report?
Page number 15, madam. 15.
15.
Number 15. Page 17 is the main.
This Nirmal Borua was there was a final report finding no case against Nirmal Borua.
Against Nirmal Borua.
Right?
Yes.
Then
page 24.
Registered as so and so and one final named as accused. Exactly the final report. That was on. Final report was on.
Final report.
Twenty-eight 9/2022.
18/9. Yes.
Right?
Madam.
Then you filed a
Complaint,
Some complaint.
my lord.
Against Hemali Das
My lord.
on 12/9/2024.
12/9/2024.
Based on what?
Based on page number 24, before one page, my lord. Page 24, my lord, column number 6, by what weapons inflicted, blunt weapon.
Okay,
This is one aspect. Another aspect is, my lord, last 2 pages may be seen. Second page from the last, my lord, there's a picture, my lord. There's a picture of the vehicle which was got accident, my lord. Page 48. My lord,
Page?
it is seen that
Page-
the
page?
page
Page?
48, 48, my lord. Picture shows that the vehicle was accident from left side, my lord. Left side, my lord, Shevali was sitting. Right side, my lord, Jonathan sitting.
Where from you are saying Savali is sitting?
My lord, from the picture, my lord, Shevali was sitting.
No, Savali was there.
There, my lord.
Who is her photo?
Photo, my lord, only vehicle's photo is there, my lord.
So you have imagined now.
No, my lord, as per the statement of the
Who? Statement of who?
statement of the petitioner, my lord, the present petitioner and his family members were examined by the trial court. I have annexed the depositions, my lord.
So where is your knowledge? Sir, on 14/8/2022, right? With your eyes and ears open, right? You lost the FIR, saying that Nirmal Borua was the driver. And because of his rash and negligent driving, my brother, elder brother, Satrajyoti Borua, died. Matter was investigated, right? And thereafter, IO submitted a final report saying that Nirmal Borua was not involved, right? My question was that whether the trial court, upon receipt of the final report, issued any notice to you or not. Have you understood my question?
Yes, ma'am.
When a final report is to be accepted, the court, before acceptance of the final report, issues notice to the informant so that he can come and show reasons as to why the final report is not to be accepted. Or he can say, yes, please accept the final report. Right. This was done in final report was submitted on 28/9/2022, September 2022. Right. Now let us see your complaint.
My lord, page 25, my lord.
We'll go to the Assamese version only.
My lord, that is, my lord, page number 33.
Now you have introduced a new story now. Right. In the complaint, you have introduced a new story that Satrajyoti Borua আৰু তেওঁৰ পত্নী হেমালী দাসে ব্যক্তিগত বাহন লৈ যাই থাকোঁতে দুৰ্ঘটনা ঘটে. Now you have planted the wife of the deceased. Earlier you planted the driver of Nirmal Borua. Right? Now, after submission of final report, clearing the name of Nirmal Borua, right? You have planted Shamali Das now inside the vehicle. And that vehicle met with an accident. And Semali Borua telephoned you, right? And then after that, something all story started. Everything started thereafter. Why you did not realize that, my question is, after receipt of notice, why did not you file protest petition?
My lord, I have filed a.
Show me your additional affidavit. Anything is done?
My lord.
Anything is done?
My
Have
lord,
you been informed anything? Please tell me.
One thing, my lord, lordship may.
Please tell me.
My lord.
You have manufactured many stories. Now you have tried to give the color of murder. Right?
My lord, page number.
From rash and negligent driving, now you have shifted to a story of murder now. Now, where is the final report? And have you received notice or not? Clear case. Yes.
My lord, one page may be same page.
No,
43.
please, no, I want the answer.
My lord.
Yes or no?
My lord,
Did you receive notice or not?
My lord, that instruction I could not.
That was precisely the question I asked to explain the delay. There could be many situations. Court has a duty to issue a notice. Whether you as the informant received a notice or not. After receipt of notice, what is your conduct? Did you file a protest petition
yes.
or not?
My lord, yes, my lord. Lordship, that is why page number 43, my lord, one paragraph may be seen, my lord. Page number 43, this is the impugn order. Lordship, 1, 2, 3, third paragraph may be seen, my lord. The page 43, the instant complaint case has been lodged by the complainant, Sri Jonardhan Borua, against Srimati Shevali Das as protest petition against the final report submitted by IO.
Where is page 43? Let us see.
Page 43, my lord.
Now, what are the new documents you have given in your additional affidavit?
Additional affidavit, page number 57. But the complaint was lodged by the petitioner on 23/6.
This is regarding investigation.
And my lord, page number 61. This is a complaint.
Same allegation, basically.
Yes.
Right. Anything new?
My lord, I have annexed certain complaint, my lord, on same incident, my lord, one after another when the.
No,
was taken.
complaint, certain allegation, repeated submission of allegation will not
Before the
make
various.
make it established.
My lord, from various authorities, my lord.
Various authorities, that will not make, because you have to make the complaint before the proper authority. You had already made.
My, I have.
Investigation was committed. Yes, Mr. Sharma.
But here is, my lord, there is two case, my lord. First one, my lord, that, my lord, 147 of 2022. That is final report submitted. And against that, my lord, whether that is any narrative is given or not, my lord, that is not clear. And
Somehow he has
then,
referred to page 43.
yes, my lord. Then, my lord, it is Silabatar PS 18.
But page 43, whether it has referred to acceptance of final report. Narazi petition.
Yes, my lord. And
What is the order, Mr., on the final report? I requested you to get the final report. What is the order passed on final report?
Yes, my lord. That is not here, my lord.
Because the order, after the deliberation, this order was passed only so that you come up with proper document, relevant document. I have not granted you liberty to bring in irrelevant documents. Am I clear?
My lord,
these kind of irrelevant documents are not, were not requested.
My lord, I have understood, my lord. I will collect, my lord.
Right. Your conduct. Because initially your theory was, my brother died in an accident
Yes.
because of rash and negligent driving of Mr. Nirmal Borua. Right? Then I said, Nirmal Borua was not there. Right? Then your mind started working, right? That deceased had obtained many insurance policies, right? Let us plant a new story. File a complaint that his wife was behind the murder. File a complaint, right? Without doing anything to the final report. Right? Then you started bringing in your sister, all these stories informed by wife, so-and-so, because nothing can be verified, right? Because that is why I wanted to have your conduct cleanly examined, so that abuse or misuse of the provisions cannot be gone on further. And if you're really in the interest of justice, this order is to be set aside, then we'll set aside. But first, two courts have already gone against you, right? Bringing a lady with an allegation of murder is not very simple. With planted theories, without anything, everything is in imagination. Everything is in imagination. Just because you have got the insurance policies.
No, my lord.
Mr. Ali, Land Council for the petition has sought further time to produce before the court to bring on record the steps taken by the petitioner subsequent to submission of the final of fine of the I can't. Steps taken by the petitioner during the period from 28/9/2022 to 12/9/2024 on the final report, final report number 150 of 2022 submitted on 28/9/2022 in connection with Silapathar Police Station case number 147 of 2022. So, as sought for by Mr. Arel is the case on after 2 years. That is the last one. Last time. Mr. B. Sharma, Land Additional Public Prosecutor is present. Because we are not finding it fit to issue notice.
Supplementary list, item 43. Lordship, engaged counsel out of station.
Engaged counsel, M. Rana. Okay, on the prayer of, you are enjoying interim order. Yes, Mr.
May I please, Your Lordship? I am for the respondent, Lordship.
Agreed?
Lordship, there
To
is,
the prayer?
I have a humble submission, Lordship.
Yes.
And the proceeding in the Honorable Family Court, that
I
is
know.
being stayed.
I know.
So admittedly, I am not getting any support, financial support.
Okay.
So that may be.
Let us put it on a fixed date.
Yes.
On the prayer of Mr.
M. Hawk.
M. Hawk, Land Council appearing for the petitioner has made a prayer for adjournment. Post of Mr.
M. Ahmed.
M. Ahmed. Have you filed objection already?
Yes, Lord.
Okay.
Affidavit in opposition.
Land Council appearing for the respondent has submitted that an interim order is in operation. Post of as sought for and as agreed to by the Land Council, but the parties release the case on
1st September, 19.
the interim order passed, I guess, shall continue till the next day.
Deeply obliged.
Item 31 for orders.
S. Parveen. S. Parveen. Submitted. Yes, done. Oh, you haven't entered appearance.
I'm appearing for
LCR has come.
LCR.
Against conviction.
Lordship.
Against conviction.
This
Okay.
entire trial order. Okay.
Okay. Then it can be hard. That is the only thing.
Yes, sir.
As Parveen, Learned Counsel for the appellant and Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam are present. Post of Miss
P. Chaudhary.
B.
Chaudhary.
Chaudhary. Learned Counsel has submitted that she has entered appearance on behalf of the respondent number 2. Post of as the TCR has been received and all the parties are represented, and the appeal has already been admitted on 22/12/2022, office to release the case for hearing. Post up in usual course. If you want early, make an application for.
Lordship, it's better to come. How nice.
32.
Yes, by order, why?
What has happened, my lord, in this matter, service has not yet been completed. There is a mistake in the address of respondent number 1. It should be Moran instead of Moranhat. We have written it.
Mr. A. Roy, Learned Counsel appearing for the petition has submitted that an inadvertent mistake has crept in the address of the respondent number 1, full stop. He has thus submitted that the petitioner be granted one opportunity to take steps for service of notice when the petitioner number 1 at his correct and proper address by registered post with AD as well as by usual process. Post of the prayer made by and made on behalf of the petitioner is allowed. Post of the petitioner shall take steps for service of notice upon the respondent number 1 by registered post as well as by usual process at his correct and proper address within 3 working days from today, list the case after 4 weeks.
Regarding the service on respondent number 2 and 3, my lord, the service was awaited long back.
Okay. In view of office note dated 7/9/2020, sorry, 7/8. You take fresh steps also.
My lord,
Huh?
my lord.
Here's the office note dated 7/8/2025. Post of the petitioner is allowed to take fresh steps for service of notice upon the respondent number 2 and the respondent number 3 also by registered post as well as by usual process at their correct and proper addresses within 3 working days from today. Correct it, whatever is, if there is anything.
Item 33.
RK more.
Right.
Yes.
I have taken the steps on the respondent number 2.
Interim order passed earlier.
Office note 7/8/25 reflects that
Office note
7/8/25 reflects that no return envelope has returned.
Neither educated nor answer notice. Nor any service report. Then take fresh steps then.
It may be taken as a DIN service as per General Project.
Nothing has come also.
Because,
Neither ID card nor answer notice any service report.
Yes, ma'am.
Similarly, nothing has been from the district magistrate.
Right.
Nothing from the district magistrate also.
For that reason, on my
You take
period
fresh
is
steps
also pending.
upon the respondent number
Respondent number 1 is
2. You are enjoying interim order.
No, no, my lord. There is no interim order. In fact, section 23 of the Juvenile Justice Act does not extract.
Problem is that. This man is a known man. Famous man. Is it not?
Hello.
Respondent number 2.
Yes, my lord. And address is also, my lord, it is in the Guwahati and my lord, not.
Why can't be served?
Not understood.
I permit you dusty also. We used to see him in the media, newspaper, everywhere. Heard Mr.
RK Moore.
RK Moore. Land Counsel for the petitioner, Mr. B. Sharma, Land Additional Public Prosecutor for the respondent number 1 post of peruse the office note dated 7/8/2025 post of. Petitioner is permitted to take fresh steps for service of notice upon the respondent number 2 by registered post as well as by usual process within 3 working days from today. Also, in addition, Kama has paid for dusty compliance affidavit 3 weeks. This is the case after 3 weeks.
Item 34.
Aye.
Worship, IAS for decision is pending.
7 years.
7 years.
376.
76.
Yes.
Yes, my lord. Rashida Begum is my ex-wife, your lordship, and
Oh,
Syed Ali is the main accused and
main accused.
and
And
partner accused of
Moidul.
Moidul Islam. Yes, madam.
Okay. They face charges under what?
Under section 457, 366, 380, and 34 IPC, your lord.
34.
Yes.
380 theft.
Theft and
That is a dead one chain is snatched.
yes, madam.
Huh? 10,000 is
Yes.
taken. Huh?
Yes, madam.
Adding masala to the fire.
Appeal and
Yes, the prosecution is at 511. Of Mannaf Ali. You are Mannaf?
I am Mannaf, yeah.
Mannaf. 311 at about the 3 absence in his house. Oh, your wife has been kidnapped
Yes, my lord.
from your own house.
From my own house and some of
Also stole away 2,30,000
Yes.
gold ornaments,
Yeah, gold
Samsung mobile.
ornaments, yeah.
Mobile is inevitably in the every affair,
It may be.
right? You had one mobile. I don't know, police has suggested it or not. But service complete?
Completed, your lord.
Service complete?
Yes, my lord. They are.
Oh, you have called her also.
No, my lord, already left the court, your lordship.
Huh?
And that's why I have called him.
So you are entering appearance.
Yes, madam.
Your name, please.
Arkha.
R. Khan. Do you have any objection?
No.
Serious objection? No. Agree to the. Heard, Mr.
I am assistant.
Assistant and counsel for the applicant. Mr. Sharma, do you have any objection? Mr. B. Sharma, learned additional public prosecutor for respondent number 1, Theta Vasam. Close club. Also heard Miss
Arkha.
R. Khan.
Kha. KHA.
K-H-A. Kha.
Yes.
Kha. Okay. N is missing. Okay. A learned counsel who has entered appearance for the opposite party number 2, 3, and 4. Full stop. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 35 days, which period of delay is stated to have occurred in preferring the accompanying criminal petition under the proviso to section 419, BNSS 2023, full stop, against a judgment and order dated 16/8/2024, passed by the Court of Learned Sessions Judge Borpeta in Sessions case number 214/2022, full stop. Para, by the judgment and order dated 16/8/2024, the Learned Sessions Court had acquitted the opposite party number 2, 3, and 4, who were arraigned as an accused therein, from the charges under sections 457, stroke 360, stroke 380, IPC rate with section 34 IPC. First off, I have got through the statements and amendments made in the instant interlocutory application, more particularly, paragraph 2 thereof. Full stop. Having gone through the statements and amendments by her, sufficient evidence, showing sufficient cause. The Learned Counsel for the respondents have also fairly submitted that they have no objection. If the accompanying criminal appeal is heard on merits after following the period of delay, which is not significant. Full stop. For the reasons assigned here in above, the instant interlocutory application is allowed. The registry to register the accompanying criminal appeal and thereafter to list the same for admission. Yes, anything? Meeting tonight? Yes.
Masala.
39.
Your Lordship. Lordship, the IA, I have filed the IA for vacation of the ad interim order, my lord.
Add interim order.
Ad interim stay order, my lord. On
Stay order.
Yes, I have annexed the order at page 11 on 25 January of 2022. Ad interim order was passed, staying the proceedings of the trial court till the returnable date. Thereafter, my lord, the interim order has not been extended further, my lord. And for the last 5 consecutive dates, the original petitioner is taking adjournments, my lord. On the last
Okay,
one-
we'll issue notice then, because he has to put on notice.
I have already served the copy because in the main petition,
Okay, but
Yeah.
You have served a copy, we have to issue notice.
I have served.
I understand.
Yes, Lordship, yes.
I have understood
Yes,
your
Lord.
case.
Yes, Lord. I'll serve. Lordship, a date may kindly be fixed, my lord.
Because if I satisfy, then only I'll proceed to the stage of issuance of notice. Okay, heard, Mr.
MM Zaman.
M. Jaman, Land Council Board of Petitioner or applicant, first of all, seeking vacation of an ad interim order of stay on further proceedings of the complaint case, CR case number 101/2020. The instant application is preferred, full stop. Let notice be issued. The notice is made returnable on so and so, as B. Sharma has appeared for the opposite party. Issuance of formal distance defense with the applicant shall serve a copy of the instant. Now, already it is submitted that the applicant has already served a copy of the instant application on the learned counsel, upon the learned counsel for the OP number 2. Full stop. Notice returnable ki kolo?
8 September.
Place the case on 8.
Much obliged.
Item 40.
Great to the Lordship, my lord. Food Adulteration Act, conviction, my lord. Company Food Adulteration Act, my lord, the person who was representing the company, he expired. Now we have filed an application of substituting the person to represent the company. Was previously representing has expired, ma'am.
What will be the implication? It is against conviction.
Company.
And conviction is against the company also.
Company, Rasoi Limited.
Yes, Mr. Sharma.
Notice, my lord.
What notice? You are the.
Oh, yes, my lord.
You are the only respondent, perhaps.
My lord.
My lord. Cheta sir.
Actually, copy is not with me. my
Copy not there.
My lord.
Serve a copy.
No.
Friday.
This Friday is holiday.
Oh.
Next week, ma'am.
Monday both fix kora ase niki? Okay, we'll take up. Mr. P.K. Rochuri and Council Board applicant is present. First of Mr. Sharma, B. Sharma, and additional public prosecutor has submitted that he is not having a copy of the instant application with him. First of, yes, sorry, copy. The applicant shall furnish a copy of the application to Mr. Sharma, B. Sharma, additional public prosecutor by tomorrow. Only 2-3 days. Release the case on Monday.
18. Item 41.
Yes, sir.
May it please your lordship. This matter come for.
It is for what?
This is for
NCBIA.
Lordship.
That
This
will,
was
that will require
on
some
this
time.
occasion, your Lordship, I have taken up the plea that.
Oh, yes.
56.
Oh, yes, yes.
So your
yes.
Lordship is given.
Now,
time.
it's
Now
not
it's
time to exercise. Okay, Thursday?
This Thursday.
Thursday or this Monday?
Lordship.
বহুত আছে নেকি 18 তাৰিখে কিবা আছে নেকি 18 তাৰিখে কৰি দিওঁ okay.
Then Lordship after
18 Tuesday.
Can it be after 21? After 21?
Oh, you read and come.
Lordship, I will
Leave
be
Cal
out of
aside.
station, Lordship.
Huh?
I will be out of station, Mr. Cal.
Leave
will be
Cal.
Mr. Cal will be out of station on that.
So you be there?
Lordship, I will be also out of station, Lordship.
Oh.
A small prayer, Lordship. After 21 days.
Yes, Mr. Manan.
We have
You
to
know.
accommodate your Lordship.
Stay for some more days. YS Manan. Applicant appellant. Mr. K. Jain, learned counsel appearing on behalf of Mr. S. C. Kyle, learned counsel for the opposition respondent NCB. As sought for to by the learned counsel for the party, released the case on
22nd. Lordship. Much obliged. Obliged.
42.
Yes.
This is Your Honor, an FIR.
Let me read.
Yeah.
Yes, respondent number 2 has appeared.
Yes, my lord, I am for the respondent number 2, my lord.
Third, Mr. G. Kosik, learned counsel for the petitioner, Mr. B. Sharma, learned additional public prosecutor for the respondent number 1 state. Full stop. Mr.
AJ Sharma.
AJ Sharma, learned counsel, has submitted that he has entered appearance on behalf of the respondent number 2. Full stop. Having regard to the issue involved in this petition, leaves the case on day after tomorrow. Day after tomorrow, at least already after 19.8. Yes, Mr. Ahmed.
44.
What?
That's it.
What has happened to
Quashing.
Masoom? He appears to be not so Masoom.
No, Malan, I am not, I am a owner of a auto driver, Malan.
No, his name
Jima-
is Masoom Ahmed.
Malan,
Masoom means otherwise innocent,
Man, innocent.
but he does not appear to be.
No, Malan, I am not a accused, my lord. In fact,
Await service report. What for what it has come?
my lord, our orders, my lord.
Orders.
Yeah.
No, either ID card nor answer notice has been received back after notice was issued to.
He is a police officer of that police station, man, who lost that.
No, notice is not served.
Well, it's a wrong.
Wait. Scan copy received.
Mali, that is your lordship, that is the decide since the scan copy the LCR already come and he is a police officer.
Who is police officer?
The respondent number 2, the informant. Otherwise, he
This
will
has
not-
to be served.
Otherwise, he will not be prejudiced, Malan. A quashing period.
That is a different thing.
Yes, Malan. That is why I am submitting.
Okay, Mr. A. M. Ahmed, learned counsel for the petition is present. Here's the office note
Yes.
dated 8/8/2025. Scan copy is that was the scan copies. NDPS case
NDPS.
are received.
Fine.
Post. I wait for the service report in respect of the respondent number 2. For what purpose? Quashing means what? NDPS proceeding.
Yes, Malan.
NDPS.
My lord. Malan, why am your lordship
Okay.
fixed on another?
Now,
date?
it is
I
not
will satisfy
possible.
your lordship, Malan.
Release the case after a week.
18.
We'll see. You make effort to release the case.
Malan.
NDPS case.
Malan, I am owner, Malan. Supreme Court.
Yes, sir, there you go.
अच्छा